equipped to be one of the best in the industry. And we'll basically spend the 2 days talking about the professional overview of the different topics that you saw on the poster with the industry experts. We'll talk about the implication of the law on some of the things that you meet every day. We will also take a deeper dive into compliance issues, into practical challenges, recommendations from the industry experts that we are privileged to have as part of our panel. So as we will take 1 or 2 minutes to allow you to settle in, make sure that you have a notebook or a pen. And also what I advise our attendants to do is make sure that the presenters do give their expertise on the different topics that they'll be sharing, that you have a notebook to prepare your questions so that you send them along, because for every panelist that we have, at the end of their session, there will be a Q&A. So send through your questions and we'll be able to sieve through and present some to our panelists to answer. Now, the good thing is that we are just talking about insolvency. We are not experiencing it. So it should be a pleasure that you are learning and picking a lesson. And our panelists are already in place. Before we start, for day 1 on the 2nd of July, I would like to recognize the presence of 2 of our panelists that are already in the room. Mr. Mustafa Ntali, the Deputy Registrar General at URSP, is already in the room. You're very welcome, sir. And our senior, I always joke that he started practice before I did my PLE. And the one and only Mr. Nelson Nelima, thank you very much for gracing us with your presence and giving us your time. And we will have most of the panelists joining us along, but at least we are good to go. Apart from the panelists, we have, of course, the support team at Uganda Law Society that is organizing this. Thank you very much for putting this together and ensuring that we have the best time in this place of learning. Finally, we are not alone as and we are not orphaned, because I don't hear me. Yes, so as I was saying, sorry about that. We are not orphaned, but we have one of the representatives of the Uganda Law Society, and that is the one and only, the most perpendicular Vice President, Asimwe Anthony, gracing us with his presence. And without further ado, I will ask our Vice President to give us the welcome or opening remarks before we dig deep into our discussion for the day. You're welcome.
Right. Thank you very much. Thank you. Please confirm you can hear me.
Yes, we can hear you, Your Excellency.
All right. Thank you. I'll first apologize for not being there with you physically. Thanks to digital transformation, which is one of our 4Ds. A good morning to everyone, our distinguished guests, panelists and participants. I do bring you warm greetings from the Radical New Power Governing Council, and specifically from the President, who is also not here with us. For me, really, it's a great pleasure to welcome everyone here to this Insolvency Law Training. And as you've heard, I believe this is one of the most critical and important areas of practice in our field today. Today, we are gathering not only to deepen our understanding of insolvency frameworks, but also to strengthen our collective capacity to navigate one of the most critical areas of commercial and corporate law. Insolvency is not merely about winding up distressed entities. It's also about balancing the interests of creditors, debtors, and the wider economy, while ensuring fairness, transparency, and sustainability. It's a bigger job. It's much bigger than it appears. So I do believe the timing of this training is really important. It's timely because most businesses across Uganda, across the sector, are facing several challenges ranging from global economic shifts to local market pressures and challenges. And I believe an understanding and a grasp of insolvency law equips us as lawyers to respond to this effectively, whether by restructuring viable enterprises, protecting creditors' rights, or safeguarding livelihoods and people's jobs. It is a discipline that demands both technical precision and human sensitivity. So colleagues attending today, I encourage all of you to approach this training with openness, and I encourage you to share your experiences. I believe that together we can build not only knowledge, but also a stronger professional bar committed to excellence in insolvency practice and serving the nation. Allow me also, in a very special way, to thank our panelists who have, accepted to support us today. Particularly, I do thank Senior Counsel here. I like referring to him as Senior Nelson Nerima for the support, for helping us put this together. I keep telling law students at LDC that they missed a lot, the ones who are there now, because they never had a chance, an opportunity to interface with this legal mind. But as the National Bar, as the Law Society, we do appreciate and thank you for your commitment to professional development and mentorship, because I believe it's part of you. That is why you've sacrificed enough. So to the people attending, I do hope that this training will, entice us and encourage us to learn more and do more and be more practical. Let it not just be another event we attend for the sake of attending, but let it be an event where we come up with something and probably commitments to do better and contribute to, the legal profession, practice, and generally the entire country and society. I thank you once again, and I do welcome you. I wish you the best of the training. But then again, also before I take leave, allow me to thank the Secretariat team for always working tirelessly to ensure that we support our members, we support the membership. We do not take that for granted. It's not just being staff, but also the commitment and the hard work you put in to ensure that you put all this together to support us. I thank you, and I wish you the very best of the day. Thank you.
Yeah, thank you very much, our Vice President, Councillor Simwe. Not wise words have been said, and we thank you also for the support that you give to the Secretariat to make sure that these such trainings keep happening, because they are important for career growth for people practicing this discipline. Now, as we were beginning, I said whether you're here voluntarily or your managing partner has forced you just because you want CLE points, by the end of the 2 days, we should be able to become at least pseudo experts in what we need to know, and I'm sure that you're going to discern most of the things that our panelists will be bringing to us in the course of their presentations. Without further ado, I'm going to introduce our first panelist. Our first panelist is, as earlier introduced, Mr. Ntale. Now, Mr. Ntale Mustafa is Deputy Registrar General in charge of registries at the Uganda Registration Services Bureau. He's been in that role, of course, previously also serving in areas of insolvency, and in the current role, he oversees key registry functions, including business registration, insolvency administration, and related regulatory services. We would spend the whole day breaking down his CV, so that's why I'm trying to give the abridged version. He's a senior legal administrator and a key figure in Uganda's insolvency and business registration reforms. That's why we have him here today. Also, he has extensive regulatory expertise, especially in his experience serving as URSP's Director of Insolvency and Receivership, where he spearheaded high-profile corporate restructuring, including the one for the famous Uganda Telecom Limited. He also represented Uganda at International Trade Law Working Group meetings and International Association of Insolvency Regulations. His key expertise, as I've just summarized above, is in corporate and commercial law, business registration, insolvency and receivership, intellectual property administration, corporate governance, legal policy, and international compliance. There's no better person to take us through our first topic, which is compliance challenges, recommendations in insolvency practice. Now, in the breakdown of that presentation, he will be telling us the most common compliance failures you observe among compliance practitioners in Uganda. He will break down our current insolvency regulatory framework. He came with a whole compendium of insolvency and company laws, so we are good to go. What is not in soft copy, he already has in hard copy. He'll also tell us more about the practical challenges and the recommendations for the industry. And ladies and gentlemen, you might want to use your emoji on Zoom and clap as we welcome Mr. Mustafa Ntali to take us through his presentation. You're welcome, sir.
Thank you very much, Harold, for the kind introduction, and good morning, everyone. I will stand on the protocol that I was earlier read out. My name is Ntali Mustafa. I'm the Deputy Registrar General at Uganda Registration Services Bureau. I'm happy to be here this morning to share with you about insolvency practice, which is one of the practice areas of interest to lawyers. The assignment which I was given today morning is quite simple, and I really hope that we should be able to appreciate all the issues surrounding about insolvency practice. And I have a PowerPoint presentation to share, which will guide the discussion, after which we'll have an interaction on the number of issues which are rising. The presentation has been displayed, and in that presentation, I hope I'll speak about insolvency, being the first presenter. I think Mr. Nilma, you'll agree that it is not necessarily an obvious concept. It will be good to first understand what insolvency is all about in 1 or 2 slides. Also give an overview of the Office of the Official Receiver, which is the principal regulator of insolvency practice in the country. Talk about insolvency regulation and compliance expectations within the Ugandan environment, emerging issues and challenges, and I should also be happy to make a few recommendations here and there for the improvement of this area of practice. Insolvency, it is really a simple concept that means inability of a person to pay his debts as and when they fall due. If a person is unable to pay his debts, be it corporate person or an individual person, we technically say that a person is insolvent, and the Insolvency Act gives us the parameters for assessing the inability of a person to pay his debts. For example, if you are unable to satisfy a statutory demand within 20 working days that has been served on you as a debtor, we can say that you are insolvent. Or if execution is levied against you as a person and it is returned unsatisfied, or a receiver is appointed in respect of your assets or a substantial part of your assets. All those are the possible grounds of initiation of insolvency proceedings. I hope I'm the one in charge of moving this. Sorry. Apologies. Let me first get to the first slide. Okay. I beg that I be the one to move, all right? Yeah. Yes, I stated basic grounds for inability to pay debts, which are set out in the Insolvency Act, and that is specifically Section 2, failure to comply with the statutory demand, execution levied against a person and it is returned unsatisfied, all where the assets of the debtor are under the control of the receiver. All of those are grounds for commencement of insolvency proceedings. I've mentioned that insolvency affects both natural persons and corporate entities, and it attracts different consequences. For corporate entities, if a person is insolvent, if a company is insolvent, for example, if a corporation is insolvent, the company can be liquidated, and basically liquidation means termination of the life of that company. So what will happen is that a liquidator will be appointed to preside over the liquidation process, and the ultimate goal is to dissolve all the affairs of that corporate entity and have it removed from the register. It can also be placed in receivership. The purpose of receivership is not actually to kill or to terminate the life of the company, but actually to settle the liabilities in respect of that were outstanding before the appointment of the receiver. Of course, it is possible that after the receivership process, there is nothing left for the entity to continue operating. It can slide into liquidation. But that's not the primary goal of a receivership process. And then finally, administration in respect of corporate entities. This is basically a rescue mechanism. Where a company is insolvent, but we believe there is hope for that entity to survive. So you appoint an administrator who reorganizes the affairs of that company, pays off the creditors, and it continues to do business. In respect of natural persons, if a natural person is insolvent, he can be adjudged bankrupt, which is not a nice thing for anybody to be adjudged bankrupt. You know, even as lawyers, when you're applying for enrollment, usually there's that last paragraph we put in our statutory declaration that I have never been adjudged bankrupt. So it's not really a nice thing, but if you can't manage your finances, then the court can make a bankruptcy order against you, appoint a trustee in bankruptcy, pay off the creditors, and later you can be discharged. It is also possible to appoint a receiver in respect of an individual, but it's also possible to rehabilitate a person who is facing financial difficulties. So arrangements in respect of natural persons is the equivalent of administration in respect of corporate entities. Yes, I'll speak briefly about the Office of the Official Receiver, which sits within Uganda Registration Services Bureau. We all know that URSB is established by an Act of Parliament with a broader mandate that is stated as carrying out registration functions as required by the different laws. Now, the number of laws which oblige URSB to perform a number of functions. And in respect of the Insolvency Act, the Act establishes the Office of the Official Receiver. I need to state that it's not the first time that the Act actually did not create this office as it did not initiate this process, this office. Official receiver existed even under the Bankruptcy Act, which we adopted since colonial times. But in that case, the official receiver's powers were only limited to natural persons because the Bankruptcy Act only related to individual bankruptcies and not corporate insolvency. So the Insolvency Act redesigned or redefined the role of the official receiver and also consolidated both corporate and individual insolvency, and made the official receiver the overall regulator of both corporate and individual insolvency. So the Act says that the official receiver has to be appointed by the Minister of Justice and Constitutional Affairs, and for that matter, the Minister of Justice and Constitutional Affairs appointed the Registrar General as the official receiver. That is the reason why the official receiver function set out under the Insolvency Act sits within Uganda Registration Services Bureau, and as we speak today, it is a fully-fledged department executing that mandate. The functions of the official receiver as set out under the law are quite clear, and as I've stated, they are largely regulatory in nature. So the official receiver has powers to investigate company affairs, and in case of fraud, take appropriate action. And these powers to investigate also extend in respect of insolvency practitioners, because it's the regulator of insolvency practice. So the official receiver has the power to investigate the conduct of insolvency practitioners, and if they are found to have committed offenses under the Insolvency Act, we have the powers to prosecute. I also need to inform the members that the official receiver has delegated authority from the Directorate of Public Prosecution, so we conduct those prosecutions should you find an insolvency practitioner in breach of the established principles. So we prosecute for the offenses arising from the Insolvency Act. Also regulate insolvency practice, we license or register insolvency practitioners. And interestingly, as a regulator, we also have powers to act as a practitioner in some extreme cases. I know this has some policy issues. This is a matter which some people have questioned. If you are a regulator, how do you wake up one day and at the same time you're also a liquidator? How do you compete with the people you regulate? But I need to emphasize that these are special cases. For example, winding ups which are coming from court. We have had a number of cases where court opts to appoint the official receiver to liquidate after looking at the circumstances of the case. It may be form an opinion that we are the best office to handle the particular assignment. But also in some cases, because there is no money and we're a public office, so court says official receiver handle this as because you're already paid as a government office. We also act in respect of assets which are discovered after the conclusion of an insolvency process. This was an amendment which was introduced in 2022. This power was not initially available to the official receiver, and it emanated from cases where, for example, a liquidator is appointed, the company is fully liquidated, and we file final reports and even get it off the register as URSB. And then after 2 years, someone comes and says there is land which actually belonged to this particular company. Recently, I came to know of one company which had even bank accounts, and there is still money. In some cases, that may have arisen because of fraud of the people who occupied the office at the time, and they didn't fully disclose the assets of the company, or out of mistake. The challenge which we are struggling with initially is how to deal with such assets, because all the affairs of the company have been wound up. And technically speaking, if the insolvency practitioner is functioned as official, he no longer has instructions to act in such cases. So in 2022 amendment, the official receiver was given those powers to act in those exceptional cases and realize those assets and distribute them as if he was the insolvency practitioner. What would happen is that because we are the custodians of the final reports which the insolvency practitioner filed, we know who was paid, we know who was paid less, we know the shareholders, so we'll basically reopen the process and distribute those additional proceeds of liquidation to the parties in accordance with the Insolvency Act. The other case which we can act is in cases of vacancies in respect of insolvency. In case there is a vacancy in the office of an insolvency practitioner, it is normal for an insolvency practitioner to resign, and between that period, from the time of resignation to the appointment of another insolvency practitioner, by default, the official receiver becomes an insolvency practitioner for that liquidation. So generally speaking, we do not accept appointments arising from voluntary decisions of companies for the obvious policy direction that wouldn't wish to compete in business with you, the insolvency practitioners. So I wouldn't wish to compete for instructions as a business is considering appointing Harold as an IP. I'm also on the table among the people to be appointed. But of course, the other, I think, exceptional case which I need to point out is in respect of state-owned enterprises. I know, for example, Uganda Telecom is a government entity, and when the government wanted to appoint an administrator, it did appoint the official receiver. And the reasons in such cases are quite understandable. Of course, we also have a quasi-judicial function. Again, this is an aspect which was introduced in 2022, arising from the challenges associated with administration of insolvent estates and the disposal of assets. Colleagues, you realize that being appointed as an insolvency practitioner and actually managing an insolvent estate, it's not really business as usual. It's not like running a normal business. This is a situation where, for example, the landlord are evicting you, the creditors are running after the assets. Some assets are really at the risk of depreciation. So ordinarily, before the 2022 amendment, if you would, for example, wish to expeditiously dispose of assets, you'd have to apply to court for directions. And the court will give you that authorization. And as the official receiver, I know we experienced this at one point when we were liquidating, I think, Nakumat. And we were renting a warehouse. And the value of the assets in the warehouse was less than the rent which we were supposed to pay. So if we had to follow the normal process, we would actually pay more as an office. So we had to make an application to court, and court authorized the official receiver to apply to sell and dispose of those assets without following the standard processes of disposal. We are fully aware that you face the same challenges. You have been liquidated, you are appointed a liquidator of a supermarket or a pharmacy, and some drugs have an expiry date of like 2 weeks from the date of appointment, and would expect you to advertise, get the best evaluated bid, and so on and so forth. Because of the practical challenges associated with securing court orders on time, the law was amended to give this function now to the official receiver as the regulator of insolvency practice. If you have been appointed and you are really faced with a scenario of assets threatened with expiration or depreciation, then you petition our office. We consider the circumstances of the matter and give a decision. We can authorize you to dispose of those assets. And then finally, of course, we also offer advisory services on a number of issues, both to government and you, the insolvency practitioners. I'll speak about insolvency practice regulation in Uganda because you asked me to speak about compliance and insolvency practice. Of course, we know that insolvency practice is really a fairly new phenomenon. Traditional insolvency, whoever could practice insolvency, anybody could practice insolvency. So we know that before 2011, that is before the Insolvency Act, which was enacted in 2011, the official receiver had no regulatory powers over insolvency practitioners. I mentioned at the start that official receiver, as an office, was established by the Bankruptcy Act, and as such was responsible for individual bankruptcies, and in that case was performing largely the functions of a trustee in bankruptcy, and not a regulation function. So the Insolvency Act in 2011 was amended, and the corporate insolvency and individual insolvency was consolidated, and therefore the official receiver was given a regulatory function. So before the amendment of the Act, it meant that if we had the cases of misconduct, for example, if a lawyer was mishandled an insolvent estate, the appropriate recourse would be to the relevant professional body. For example, the law counsel would be the one to handle that case. Of course, it would be extremely complicated if the insolvency practitioner so appointed was not from a regulated body, because there was no qualification requirement, anybody could be appointed. So if you don't belong anywhere, in terms of disciplinary action, the complainant would struggle, and of course the only recourse would be to the courts of law. So the Insolvency Act 2011 introduced and really amended the regulatory landscape by professionalizing insolvency practice, establishing the office of the official receiver and determining who can qualify to be an insolvency practitioner. So it basically locked out a good number of people to join this insolvency, this area of practice. The question is, why was it necessary for us to focus on regulating insolvency practice? Especially that, as I've mentioned, the official receiver was initially handling this area, and I would say quite effectively. From the practical point of view, the economy grows, and definitely it was impracticable for the official receiver to continue as the liquidator, administrator, receiver, trustee of each and every failing entity. So from a broader policy perspective, it makes more sense to grow a profession to grow a body of professionals to focus on regulating this area of practice, who can serve people beyond Kampala and Soroti, Kamwenge. You have all practitioners around the world to address the needs of the economy. The other driving factor is what appears in the International Association of Insolvency Regulators principles. Uganda is a member of the International Association of Insolvency Regulators, and it passed or it enacted the set of principles to guide the regulation of insolvency practice. And one of the reasons which is stated as the basis for regulation of insolvency practice is that insolvency practitioners' actions, decisions, and omissions generate externalities. What that means is that the decision of an insolvency practitioner affects persons beyond those who actually appointed him. If, for example, a company is undergoing a liquidation, the law says the shareholders will pass a special resolution appointing a liquidator. That's a boardroom decision made by the shareholders. Or in some cases, one creditor petitions court, and the court appoints a liquidator. But there are so many other stakeholders being affected. For example, you have employees, you have a tax authority, you have the wider economy, you have shareholders. So because usually decisions to appoint a liquidator or an administrator is actually not made by all the stakeholders, yet those stakeholders have an interest in the insolvent estate. They have a legitimate interest in ensuring that all what is done is in their best interest. And because the decisions that are taken by an insolvency practitioner affect those persons who are not party to the appointment process, it is extremely important that government or public office regulates this area of practice for the greater benefit of all the stakeholders involved. I also seek to have an independent and competitive profession which provides high quality services, acts transparently with integrity, and considers interests of all stakeholders in a particular case, and also want to maximize value, protect and maximize value for the benefit of all interested persons in the economy. A creditor is interested in recovering the highest amount possible in the circumstances. Similarly, a shareholder who picked his money and invested in this entity, beyond settling his creditors, is also interested in getting a return on his investment. So it does not necessarily mean that when a company is insolvent, the shareholders lose an interest in that entity. They have a legitimate interest. So maximizing value benefits all the parties, including the creditors who may have initiated the insolvency process, as well as the shareholders of the entity who are actually having a legitimate interest in that company. Who is regulated? What are the expectations from our officers, the official receiver, colleagues on call, and everyone listening in? If you ever receive an instruction to act as a receiver or to act as a provisional administrator or an administrator, a liquidator, provisional liquidator, proposed supervisor, or a supervisor, and even a trustee in bankruptcy. If you ever receive any instruction, please note that you are being asked to act as an insolvency practitioner. So all those capacities you may wish to act as a lawyer. If you choose to act as such, we say in law that you are an insolvency practitioner. That's what Section 207 says. And all the rules applicable to insolvency practitioners will apply to you. For that matter, it is important to check the qualification requirements expected before you take up the assignment. The first one, I think it is a tick for all of us who are on this call and attending. You must be a lawyer. Insolvency practice is restricted to lawyers. It is also restricted to accountants, all chartered secretaries. Those are the three professions which are ring-fenced for insolvency practice. There is a debate on why only these ones. Why shouldn't surveyors be also in charge of liquidating real estate businesses? But that's a discussion for another day. And I don't know who will engineer it, but as far as we speak today, those are the three professions which are authorized or recognized to practice insolvency. Number two, you must be a member of a professional body, the relevant professional body. So lawyers must be a member of Uganda Law Society. And for accountants, you must be a member of the Institute of Certified Public Accountant. Of course, this is for obvious reasons. As regulators, you must also be regulated somewhere. You must be coming from somewhere. So you can't be just in the space and you want to practice insolvency. Then finally, you must have security or professional indemnity for the proper performance of your duties. This one would normally, as an office, would normally demand for the firm, the insurance cover for the firm. And the idea is that because appointments for insolvency practitioner is personal, it's a personal appointment. So you don't appoint a firm as a liquidator, but you appoint interim staff practicing with interim and company advocates as the liquidator. So we are cognizant of the fact that I can mess up the liquidation. And when I mess up, I may actually be unable to cover all the costs that are coming from that mess up. So the professional indemnity should be able to come in and cover me for the liabilities that may arise. Of course, there has been a debate on how much it should be. As an office, I think we haven't been very strict on how much, for an obvious reason. I cannot assume that all the 20 liquidations you're handling, you're going to mess them up. So I will not demand for $1 billion cover if you're handling $1 billion assets worth $1 billion, because it will be unreasonable for me to assume that all of them, you are going to really mess them up and they're going to bring about liability. The Act, I need to mention this, in subsection 2, gives the minister powers to prescribe additional qualification requirements for you to practice as an insolvency practitioner. Again, this is an introduction of the 2022 amendment, and where it came from was to address a question. You see, the Act prescribes these requirements as minimum qualification requirements. So if you come from law school, and I think by the days we studied insolvency used to be an optional course. I think even I tell this, it wasn't there recent, I noticed taught. You would qualify to be an insolvency practitioner, and I would register you as an insolvency practitioner. I wouldn't have a reason to refuse. Experience, no experience, you have the qualifications to act as an insolvency practitioner. You could be appointed to handle the biggest company in Uganda. You have all the qualifications. So we thought, or government thought it wise, that it may be important to really raise the bar slightly higher by requiring some kind of training. And this is the practice elsewhere. For example, in UK, you don't just become a lawyer and become an IP immediately. You must undergo some kind of specialist training in insolvency. So this is not yet, the minister has not yet prescribed additional qualification requirements, but that's the context that was envisaged. And I know we are going to work on this and really have some, we go beyond being a lawyer to really have some experience in terms of, in this area of practice before you are licensed or registered to be an insolvency practitioner. Yes, after we, sorry, just a second. My brother on the system, I requested you allow me to be the one in charge of movement of slides. Sir? Can you bring back my presentation and I get the slide? Okay, technology is doing us a favor, but we shall get there. Sir? Okay. Okay, thank you. Thank you. Yep, sure. That's where I was. Okay. The Insolvency Act requires that before you practice as an insolvency practitioner, you register with the official receiver. And so if you have those qualifications, the requirements, you meet the minimum requirements as I discussed earlier, you apply to the official receiver, you give us your certified academic documents, proof of membership in a professional body because it's a requirement, professional indemnity, evidence of a bank account for insolvency matters. This is extremely important because the law requires that you don't mix your money with the money of the insolvent estate. And then you apply to the official receiver. This is an online application through our online systems, and we process. Usually it doesn't take, it takes, within 1 day you should be able to have a feedback on your application. Now, subsequent to, of course, the register started in 2018. The insolvency practitioners regulations were enacted in 2017. So in 2018, URS established an insolvency practitioners register. It opened with 6 insolvency practitioners, and it has kept on growing. As we speak, we are now in hundreds of over 100 insolvency practitioners. And I encourage all of us to take up this assignment. Of course, some of you wait until when the appointment is knocking and then you rush to register. But it's also good to be registered and you wait for instructions. It just costs, I think, 155,000 to be registered, and it is just annual. It is renewed annually. Subsequent to registration, as an insolvency practitioner, as an office, we have expectations from you. One, you must prepare and submit regular reports in respect of the insolvent estates. We know when you are appointed either as a receiver, liquidator, administrator, you have a duty to file a preliminary report the moment you take up the assignment. And then after 6 months, you have to file interim reports with the official receiver. And also, at the end of the liquidation process, you must give us a final report. So we expect, as an office, that you should comply with those obligations. Of course, there are also sanctions for non-compliance, which we may choose to invoke if we find that you are not complying. You also have a duty to file annual returns in respect of the estates you have handled. This is basically like a summary of what you handled in a whole year as an IP. So it's like a consolidation of all the liquidations or administrations you have handled. And that is also done once in a year, and it's a precondition for a renewal of a registration certificate. We expect that when you resign from office, you inform us. So we expect that you notify the official receiver upon your resignation. And the reason for this is what I stated earlier, that whenever there is a vacancy, in an office of an insolvency practitioner, the official receiver automatically occupies that office, but also takes steps to ensure that another insolvency practitioner is appointed. We have had cases where the practitioner just abandons the estate, and when you follow up, says, and there was nothing to recover, and I closed the chapter just like that. So it's extremely important that whenever you are seizing or you are vacating that office as an insolvency practitioner, you inform us, and we take it up and appoint an alternative insolvency practitioner. There is also something interesting within the Value Added Tax Act that you must inform the Commissioner General in writing if you are appointed for tax purposes, and we expect that in the performance of your duties, you comply with the code of ethics that is set out in the insolvency practitioners' regulations, which I'll briefly highlight in the next slides. I think it is extremely important to know that as you are regulated, you need to know the standards which you must follow in your area of practice. So the ethical standards for insolvency practitioners, these are largely currently set out in the insolvency practitioners' regulations, which were passed in 2017. And of course, the overriding principle is that you have a duty to act diligently in learning the affairs of the insolvent, to ensure an advantageous realization of the entity's assets for the benefit of all the stakeholders. Before we had the 2017 regulations, of course, we can't say there were no standards. There were standards applicable to you as a lawyer. There are also standards applicable to accountants, but because they were being brought together by one common area of practice, which is insolvency practice, we thought that it's prudent now to have a unified code of ethics for insolvency practitioners. And these appear in the schedule to the insolvency practitioners' regulations. They emphasize integrity in the work you do, so you must maintain honesty in all your professional and business relations with your client. You must also act objectively without bias, avoid conflict of interest and undue influence. You must demonstrate professional competence and ensure that the client receives competent professional services based on the current developments in insolvency practice. We also expect you to act with confidentiality and not disclose any information which you have received in your official capacity as an insolvency practitioner to third parties unless you have been authorized. Also expect you to act professionally, and I added that the IAIR principles on insolvency regulations emphasize that you shouldn't accept an appointment for which you do not possess the requisite experience or expertise. In other words, you be honest to yourself. If you have been appointed in respect of if a company is manufacturing ammunition and you are being appointed, be honest, and you say you don't have experience in manufacturing of ammunition, and they can look for someone else. Yes, that is like a caution, so to speak. But it does not necessarily mean that for you to be appointed as, for example, a liquidator or an administrator of an engineering firm, you must be an engineer, or a pharmaceutical company that you must have experience in manufacturing drugs. You don't have to be a pharmacist, but you must really have those basic. You must have basic knowledge. If it is too complicated for you, please be honest to yourself, and the instructions are passed to the next person. A few things I need to highlight on potential areas of liability as you practice as an insolvency practitioner. I emphasize and note that insolvency practice or insolvency is not really business as usual, and we are fully aware that the actions you take, you don't take them in a normal business environment. They are really business decisions. That notwithstanding, the actions you take can attract liability. So, notwithstanding the complexities associated with the environment in which you are operating, you can still attract liability as an insolvency practitioner. And as an office, as I mentioned earlier, we can even prosecute you for the offenses you have committed. This is when the professional indemnity comes in handy. You can rely on that cover as a practitioner if liability ensues. You may wish to rely on your professional cover to address some of the liability that is arising out of the process. But it's also important to note that you can try to mitigate those potential areas of liability. For example, court supervises the work of an insolvency practitioner, and if in the process of administration of an insolvent estate you think an area is not clear to you, you apply to court and seek for directions on how to address a matter. It's one of mitigating potential liability, and you know court order is a court order. If I have a court order telling me to sell, don't ask me why I sold. The reason is court authorized me and directed me to sell, and the factors which were considered will be left to court. So I would encourage that instead of really taking high risks in your practice, you go to court in some cases and seek directions from court. Some powers, as I mentioned earlier, some powers have been devolved to the official receiver. I earlier mentioned the powers to give directions on disposal of assets that are threatened with depreciation or devaluation. Those powers have now been devolved to the official receiver. There is a debate which probably we can continue with, and I'll also be happy to pick views of the members here on devolving more powers to the official receiver, more quasi-judicial powers to the official receiver. Of course, we know if you are to file, if you are appointed to done, you want to dispose of before the end, before end of next week. I don't know whether you will succeed in getting a hearing date before next week. Yes, but we believe that official receiver can conveniently and expeditiously look at some of those applications and give directions, because he's an office of court, he's a public office, and he's also the regulator of what you are doing. Yes, emerging issues as I seek to wind up. We note that insolvency proceedings, the ones where there is actual insolvency, they are still quite lengthy because they are subjected to court processes, creditors' meetings, and costly also, because you'll be required to appoint a professional. This is already a financially constrained business, and you need a professional on board who doesn't work for free. And of course, again, as you are aware, your remuneration is paid in a priority out of the insolvent estate. So that's how complicated it can get. So we find that at times the estate is seriously constrained with the resources because of the lengthy process and the costs associated. We tried to address this in the 2022 amendments, both to the Companies Act and the Insolvency Act, when we created the two exit points. Initially, whether the company had assets or liabilities, it had to appoint a liquidator. So we borrowed the model we see, for example, at airports. When you have nothing to declare, they tell you to exit quickly. But if you have something to declare, you go through customs. So we borrowed the same analogy and said that for those entities which have no assets, we don't really have to subject them to a lengthy insolvency process. So we basically introduced what we call the no asset procedure for those entities which do not have those assets. So if you receive clients with those scenarios, it's just one advertisement, no objection is received, then the company is got off the register. It is also possible that the company has assets, but you choose to first deal with your creditors, either as a company or even you as a lawyer before you go through a lengthy liquidation process. You deal with your creditors, settle them, and then you handle it as a company which has no assets and liabilities. So we tried to manage that area in those amendments. There's an interesting area here, insolvency practitioners' fees. They are not regulated. We know lawyers, we have a scale of fees, and that scale was revised, I think, in 2018, if I'm not mistaken. We didn't touch insolvency. So now we have had the cases where the practitioner pays himself all of the money. And the dilemma is that when you look at the Insolvency Act, the practitioner's remuneration is paid in priority. So after paying himself, he says nothing is left for the creditors. all the shareholders. And then when you inquire into the basis, you don't have a clear basis to challenge him. Because as I mentioned, this is the handling an insolvent estate is not really a normal business. So we think we need to have a discussion on the scale of fees, probably having a scale of fees, all agreeing on who regulates fees. In some jurisdictions, fees are set by court. You file like a bill, so to speak, in the court, and they tell you how much you'll charge for that liquidation. I think in Singapore, you file that bill with the official receiver. So the official receiver, you tell him how much you're charging, and then he advises on what is reasonable in the circumstances. I don't know whether I'll have that discussion today, because it is definitely touching your interests, but it's something which we must have as people in this area of practice. We also have some cases of non-compliance on your side, both in terms of statutory filings, and also in some cases you abandon these liquidations and you don't conclude them. I think that is not good professionally, so we need to improve on that, on those areas. Some insolvencies are subject to court processes, and we don't control court processes. We know you can liquidate a company by a court order. You can, if you're insolvent, if a company is insolvent and you apply to court, I don't know how soon you'll get a hearing date. If you need protection, you want to place the company in administration, and you are threatened by creditors' action, it may not be that easy to get out to those orders in time. So that is a process which is subject to, which is a court process. Institutional coordination in relation to insolvencies affecting regulated sectors. I'm happy that on the program we'll have a discussion from on liquidation of financial institutions. That's an interesting area. Because financial institutions, for example, even insurance companies, they are registered by the Register of Companies. They're actually companies, but they're regulated. And we know there are powers under those respective regulatory legal regimes that provide for insolvencies in those cases. First of all, I must state it is the standard across the world that these regulated entities, their insolvencies are actually governed by the sector regulators. But then the relationship with the parent register is something which we need to think about. You must be aware of Crane Bank. I think BOU case went up to Supreme Court, and the question is whether such a liquidator is a liquidator of the company, or is a liquidator of the financial institution business. Really, I'll make time and participate in listening in this discussion. It will be an interesting discussion. But we have such cases. The good thing is that the engagement is happening. Again, as I conclude, I have some areas which I need to emphasize for the benefit of all of us. I encourage all of us to continuously improve ourselves as far as insolvency is concerned. Insolvency is not everyone's meal, and on this note, I appreciate the Uganda Law Society for organizing this engagement. I know there are so many years they used not happen, but if we have it on our calendar, really it's a very, very, very big achievement for us to come here and share experience and learn from each other. Of course, on our side, as Uganda Registration Services Bureau, we also putting in place mechanisms to ensure that we enhance both the capacity of our insolvency practitioners, but also ourselves as regulators. As far as insolvency is concerned, by putting in place a number of engagements, we normally have an insolvency conference, which I encourage all of us to attend whenever you're invited. And there are knowledge sharing platforms for us to learn and become better. We also launched an insolvency journal, and a good number of you are contributors to that journal, which we issue annually. Encourage you to continue sharing your knowledge for those who have the knowledge to share, but also the ones who are desirous of consuming that knowledge. I also encourage you to continue consuming that knowledge as we push it out in the insolvency journal. Case Digest from URSB is also an initiative intended to enhance our capacity. This is also an annual publication for how insolvency cases, and they're intended to sharpen our understanding. We have an Association of Insolvency and Business Restructuring Practitioners of Uganda, which was established in 2018, meant to bring together insolvency practitioners. I encourage you to subscribe to the association and be active members. Even in absence of in absence of the regulator, you should be able to grow yourselves within the association. There are other international platforms which I would strongly recommend for us to get better. I have the Africa Roundtable on Insolvency Reforms. I think the upcoming meeting is in Nairobi. Participation is usually open. You can search about it and express your interest. I know a good number of practitioners from here. Do not miss that. And it's really a very good platform for all of us. We have the Global Insolvency course offered by Insol International. It's also available. You can take it up to become better. And as I mentioned earlier, we to engage the minister on those additional qualification requirements. First, to determine who will join the profession, but also to ensure that the ones who are there become better each and every day that passes. On remuneration, of course, I've mentioned that we need to have a discussion on the standard scale to apply, whether we should have a standard scale, whether this fees should be set by the official receiver, or the court should determine. Currently, because the official receiver doesn't have that statutory power, and the court has powers to direct, I've seen cases where a liquidator or administrator goes to court and has his bill taxed, so to speak, and gets paid. Insolvency matters in court. This is something which we are working on. We had made some good progress. We know that as we are regulators of insolvency, these matters actually emanate from court, or they are influenced by the dates as given out in court. So we, as an office, we work with the Judicial Training Institute to really focus on commercial court and the civil division of the High Court, where most actual insolvency matters go. And we engage to ensure that these cases are prioritized. The ideal, which is happening in other countries, is actually to have a specialized court for insolvency matters. We have had engagements with the current Chief Justice, and this is something which he had agreed with in principle, but it's not yet, has not yet been realized. And the whole idea is speed. If the entity is going down, and the hearing date I'm getting is for November 2026, it cannot work. It cannot work. It cannot work. So if it's going down, it must really have expedience in determining those matters. So for as long as we haven't gotten that court, our emphasis now is really to strengthen the capacity, engage and strengthen the capacity of judicial officers, and also understand the context of these insolvency cases, and give them priority if they are brought to their attention. I know already a good number of judicial officers have this at the back of their mind. If it's an insolvency case, it can't wait. We have to offer a solution quite immediately. Finally, on harmonizing the regulatory landscape for regulated entities, we're already engaging our sister regulators. The Bank of Uganda, I've held engagements with the Bank of Uganda. We're also engaging Insurance Regulatory Authority, again, to harmonize these regulatory regimes to ensure that the insolvency processes under the Insolvency Act actually speak to the insolvency processes under the Companies Act, and we minimize the confusion in the market. Ladies and gentlemen, I think I have tried to keep my time. Thank you very much for listening to me, and I'll be happy to receive feedback or questions on any matters arising from what I've stated. Thank you very much.
We have an active class, so I have not seen enough emojis for clapping. I need to see more before we proceed, because it's been a worthy presentation. Yeah, I see you. Thank you very much, Ms. Antali, for a very wonderful presentation. And as I said at the beginning, it's very good that we are just talking about insolvency and not experiencing it. And it's a very different experience. And one of the things that you shared that is also a concern as we wait for questions, I have encouraged our members to share their questions in the Q&A. We have received one, and we have 10 minutes for Mr. Ntali to answer a few questions, but I just wanted us to go and address two issues. One, which did not sit well with some of the young insolvency practitioners, the whole procedure of no asset winding up or closure of companies, because previously it was a sort of grooming area for young practitioners, that you have a company, it's voluntary or it does not have assets, and they would go through that as they build towards a new experience. But now you designed a procedure where you put it outside the act and someone can just close the company. Maybe you will elaborate how that is working and what were the policy consideration. And then the second question that came in was the comparison between creditor, I mean the whole reality in the market for compliancy on creditor interference and data non-cooperation. And for you to share notes on how that works, what the young practitioners should know to prepare for that. Maybe we can tackle those questions as we wait for more to come. I see one from Samuel Akori will be tackling that as you answer those two. Please proceed.
Okay. Thank you very much, Harold, for those questions and actual concerns, and some, especially on the first one. I think on the no asset procedure, it's really about balancing interests, in my view. To start with, even no asset procedure, they're actually your clients and you're the ones. They are, because people come to you and say they want to close the company. And the company, when you inquire, says it has never traded. We opened it, we were looking at maybe big contracts, they didn't materialize. Please help me liquidate this company. Now, first of all, it is true that that person can close it on his own, which probably is, I would say, is an unintended consequence of when we are addressing your concern. But the biggest concern which you received from you practitioners was, why would I really be filing reports in respect of a company which has no assets? And a very good number of them, they would come to office. First of all, he gets appointed as an insolvency practitioner, advertises in the Gazette, all right? Prepares a preliminary report which says all assets nil, 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 nil. So I'm also supposed to keep that report which has nil, files an interim, calls a meeting, a final meeting, to consider nil, nil, nil. I think the consensus which was building at the time was this is really a process which is adding no value. Yes, but also aware that an insolvency process is meant to address stakeholder concerns. So the idea was, for these ones which really have no assets, let them get off. Of course, the unintended consequence is that it can also get off by the creditor himself, but rather by the shareholders themselves, without engaging you as a lawyer. But I also know, as a matter of fact, a good number of those notices for removing those entities with no assets is actually, they are done by lawyers. Yes. So I'm trying to say that we simplified the work for a lawyer. We sought to simplify the work for the lawyer. But as a result, of course, there may be those which may go to the to persons who may not seek the services of a lawyer. But it's also not common knowledge for a person to know that it is possible to get off that entity. It is also legal advice, so it requires legal knowledge. So it is not necessarily putting lawyers out of business, but the ones who know that there is that procedure are actually benefiting from that. Yes, so those cases where a person does it on his own, I must say that is an unintended consequence of that reform. But the purpose and intention was really good and intended to simplify your work as lawyers. Creditor cooperation is quite a complex matter. Even debtors cooperation, not only creditors, even debtors become stubborn and they don't cooperate. Of course, the Insolvency Act puts in place a number of mechanisms for you as a practitioner to address these matters. Creditor cooperation, one of the best mechanisms to engage creditors, to get creditors on board, is establishing the committees of creditors. They are provided for under the Act. You allow them to form committees, and you agree to have a structured engagement instead of each creditor coming to your office and asking for. They are all asking for totally different things. So committees are extremely important for managing stakeholders, creditors' interests, and other stakeholders. Debtors cooperation, yes. The beauty with this is that the law gives you a lot of powers as a practitioner, including court orders, but also depends on the processes. The biggest case of debtor cooperation is in respect of assets. If you have been appointed, you want to access bank accounts, you have come with this power, court order, you have a court order. The truth of the matter is that it is not common to find a debtor who tell you all his affairs. Yes, they're interested in hiding some of those assets. They're interested in not disclosing some bank accounts. And now as a registry, I think that's where when we're improving, it is for the benefit, and we're trying to address these matters. Because as I speak today, you can, if for example, a bankruptcy order is made against myself as a person, you can ask URSB to tell you all the companies where you have an interest. Yes. I think even Minister of Lands can. The Lands Register can also tell you the land I'm holding. So beyond my attempts to actually hide, the registries, the national registries are improving in ensuring that these assets are available. For banks, of course, I know my rule is you write to every bank. Whenever we're appointed as official receiver, I write to all banks. Tell me if Mustafa has an account here. And if they don't have, they should tell me. But if they conceal, then they become accomplices in the process. In most cases, they comply. So those are the areas. But of course, as I mentioned also in the course of presentation, the court is available. If you need additional assistance from court, apply for those court orders. And the court will be able to give directions on any emerging issues in the liquidation process. Thank you.
Wow, thank you very much. I hope your questions are answered. I have a vote of thanks for you from Lillian Mavis to Mizere, who's just thanking you for a very insightful presentation. But we have one more question, which is the last one, before we let you go from Samuel Aquarimo, who's saying thank you for the presentation. And he's asking, what is the experience on insolvency matters in the area of proliferation of entities involved in financial management matters other than traditional banks? And he gives an example of money lending companies. And then the second phase of the question, this is not an AI question. He asks, do URSB statistics indicate any trends related to such entities? I ask the question mindful that such proliferation is a dynamic in the country financial sector and socio-economic growth. For moderator's attention, I request reactions to these questions by all resource persons, mutatis mutandis, based on the distinguished portfolios. Maybe it's a question that we'll keep repeating for the panelists. Have you gotten the gist of it, or I just need to summarize it?
I think the first one, I didn't get it very well.
So he's basically asking your experience in the area of proliferation of entities involved in financial management. You partly tackled it because of the nature of financial institution as far as insolvency is concerned. Actually, one of our panelists is one of the things that we'll talk about. Maybe you can just tackle it a little bit, and also in line of money lending companies, etc.
I think financial institutions, as I stated earlier, they have a separate regulatory regime. for insolvency processes under the respective legal frameworks. And I also mentioned that this applies to even insurance companies. Money lending businesses, I don't think they have a specialized regime. They are treated as companies unless they are regulated as financial institutions. So if they are regulated under the Financial Institutions Act, now that is not necessarily, the starting point is actually not URSB. It is with the regulator.
Yeah.
In terms of numbers, they are not really very many. And I don't know whether my guess will be right, but that's a sector which not everyone enters. You don't just wake up one day and unlike these mobile money transfer companies, you can wake up and start transacting as a mobile money agent. But for you to become a financial institution, for example, before you get a license, the process,
regulatory requirements will.
Yes, yes. So I would say the failure rate is really not high. In terms of statistics, we really don't have those high numbers on our side. And also the beauty is that because they serve the wider public, they also usually public knowledge. You can easily know that such and such a bank is going down, or a microfinance agency is going down. But so in terms of statistics, they are not very high, possibly because of the regulatory requirements that you must comply with before you join that sector. I hope I've tried to address.
Yeah, thank you very much for your time, for the presentation and answering our questions. Mohammed, I've seen your question, but it will best be answered by our next presenter. And for now, we want to send our thanks to our first presenter. Thank you for making the time. Thank you for serving the nation. And we will straight away transition to our second panelist, who is taking it. And as he does that, allow me share with you what he will be talking about. Our next presenter will be talking about the alternative approaches to distressed assets. One of the biggest issues that we are dealing with as an industry is that most people view insolvency as ending businesses as opposed to giving them or throwing them a lifeline. And in the presentation by the person I'm about to introduce, we'll be exploring the innovative strategies, legal and commercial considerations, and the practical implementation of this subject that I just introduced. He will help us break down, of course, things like what should stakeholders consider in terms of alternative approaches instead of just formal insolvency proceedings, practical application of subjects such as the factors that lenders and creditors should consider before choosing alternative restructuring, and etc. And ladies and gentlemen, to help us do that is the one and only Mr. Joshua Ogwal. Like the first presenter, since we are going up to, I will give the abridged. We would give the whole day to break down his very rich CV. He's a partner at Legal Mark Advocates and the joint managing director for which is services. I don't know if you can hear me. Yes. Highly recognized by the International Legal Directories for his expertise in project finance, corporate governance, mergers and acquisitions, infrastructure development, and debt restructuring frameworks in Uganda. The gentleman next to me also routinely advises financial institutions and corporate clients on maximizing the recovery and alternative management of distressed corporate assets. He serves on industry advisory bodies, including the Uganda Chamber of Mines and Petroleum, and also importantly, he also contributes legal and advisory expertise to our fast-growing mining and petroleum sector. So ladies and gentlemen, we welcome Mr. Joshua Ogwal. Don't be deceived by his housing. He has a very rich experience in what he's about to talk about. I've just broken down. Mr. Ogwal, you're very welcome to take us through.
Thank you very much. I hope I am sufficiently clear. As I was thinking on how I could position this presentation, I thought I would do two things. One, I would be very selfish and position it in a manner that demonstrates how distressed asset investors should look at distressed assets as an alternative.
Can we draw the mic close?
As an alternative asset class. So that's a rather selfish positioning the presentation. The other way, in a manner that demonstrates to you, most of whom are lawyers, it actually creates an opportunity. It's an advisory, very strong advisory opportunity that you can to your clients, and an opportunity to give them access to alternative capital potential. Okay, so I will go into the presentation, and we'll begin really with the basics. The basics being, what is distress? The way we normally think about distress is rather erroneous. Traditionally, we consider distress to have occurred only in a situation where an entity has failed or begun to fail to pay its debt. Unfortunately, that is not the case. Distress is more insidious than that. It begins to occur much, much earlier. And we'll go into the drivers of distress. But many times, the failure to repay debt is only evidence or a maturity of distress that started months before, or probably in some cases even years before, and decades before, depending on the amount of solvency capital this entity is receiving. Now, many times you don't quite see distress because a company may be servicing one or two big clients who are still betrothed to it for one reason or another. So they have that easy source of cash flow. Or they may have access to easy debt at a fairly low price. So that continuous flow of cash helps to hide distress many times. But distress is a lot more insidious. So the first thing we need to take away from this is default is not distress. When default occurs, default is only maturity of distress. And I'll explain why that's an opportunity for you as lawyers. So what are the real drivers of distress? The first is at a micro level with the entity itself. And it's really around governance issues. So the quality, the structure and quality by which the business makes its decisions. That is something that will determine whether the decisions are decisions that create value or decisions that destroy value. And that is where distress begins to occur. Also, that structure will determine whether you're making decisions that increase risk or reduce risk. So it all begins with your structure of governance. Now, when you have dealt with the structure of governance, there are other things that will then come in. How are you managing your liquidity discipline? Are you managing your liquidity discipline? How are you managing your capital? How are you allocating your capital? But all of this essentially flows from the first, which is the structure of governance. The other element, which again is a micro driver, is what are the internal controls you are putting in place to ensure that the key elements of the company or of the business are actually achieved, which they are supposed to achieve in order to move forward. So all of those are micro drivers. And if you begin to think around some of the clients that you advise, or I dare say your own businesses, you will find that there are a lot of issues in some of these micro drivers that are not well aligned in both your clients' businesses as well as your own. The other would be what we call mesofactors, which are really intermediate factors. Now, these are not fully in the control of the company, but they are sudden shockwaves that may be unique to a sector that the company is operating within. So these are really shocks that hit you and then create an exacerbation of the distress. An easy example would be if you have a client that is operating in the plastics industry and government announces that there's going to be a ban on plastics or on Cavera. And unfortunately for you, the government you voted for did not come into power. That is not good for you. Distress will occur immediately. So there are those mesofactors that are unique to a sector. They don't go across the economy, but they affect the ability of the business to operate. And those need to be dealt with immediately or they can result in failure. The third, and this we saw at a very wide scale during the COVID pandemic and right after the COVID pandemic, and these are really macro factors. Issues like inflation, including imported inflation, which we saw post-COVID and continue to see now because of what's happening in the Middle East. Issues around forex fluctuations, which continuously occur. So, and what this tells us is businesses do not operate in a vacuum. Businesses they operate within the structure of their economic environment. So you cannot ignore what's happening in the country. You can't ignore what government policy is with respect to growth. You can't ignore where government is going to be placing tax incentives and where they'll be removing tax incentives, because that will affect you, it'll affect your client. I will go to the next. I hope it will appear on the presentation. But the next is really now around the issues that, before I go into the issues, into depth on the issues that drive distress, I'll again just emphasize why this is an opportunity for you as lawyers or insolvency practitioners. The whole issue around distressed assets is not one that is unique to Uganda. It's spread across Africa. And the sector that you will most see it in is in the banking sector, where banks, because of regulatory requirements, are having to report their NPLs. Now, to the extent that you have a asset base in the banking sector across Africa, for as long as there are proportions of that banking asset base that are either non-performing or are in write-off, that is a huge opportunity for distressed asset management. It's a huge opportunity for turnaround advisory. It's a huge opportunity across industries, across the continent. Distress is distress, whether it occurs in Uganda or in Kenya or in Algeria. The levers for resolving distress are really the same. So if you can do it in Uganda, you can do it in Tanzania, you can do it in Algeria. And that creates an opportunity for you. So essentially in Africa, the opportunity is a 126 billion opportunity. And that is just what is reported. Obviously, as we know, in many economies in Africa, the larger proportion of the economy is unreported. So you're really talking of a much larger scale of distress. And distress doesn't mean death. Distress just means this is a company that needs to be supported so that it can be made more competitive. So what are the indicators of distress which then need to be addressed? Now, what I mentioned earlier on is financial distress really is what I would call the maturity set of indicators. These really begin to reveal themselves when distress is maturing and it's about to result in complete default and business failure. And this really, first and foremost, begins with covenant breaches of any financial obligation that the company may have. And the covenants that you really will be looking for are two. One is the the capital covenants, the covenants around particularly leverage, debt to equity mix. If it goes beyond, if the debt equity ratio of the business you're advising or your business goes way above the industry average, then there's a problem, because you're about to see eventually resulting default. Or, and this is again the second set of ratios you'll be looking at, which are now the liquidity ratios. The first, which would be interesting for transaction lawyers to look at an early stage, is whether there are defaults around things like the debt service coverage ratio, or around the current ratio, which is the ratio of current assets to current liabilities. And this tells you of the ability of the company to meet its financial obligations as they fall due. When breaches begin to occur here, and they normally occur in a very systematic way. When they begin to occur here, then you can tell there's a red light, there's likely to be distress further down the line. The other element of financial distress is the over-reliance on short-term financing. Now, this is particularly persistent in countries like Uganda, where we don't have great depth in our capital market. So what normally will happen is a business after a certain stage will begin to borrow short-term expenditure. Now, mismatch between it is receiving its revenues. So that reliance is an that you should be consistently looking for. The third on the financial distress angle is working capital. Working capital really is that amount of cash or credit that you need to operate your business on a daily basis. It is money to pay for the production of the widgets if it's a manufacturing entity. It is money to pay for the salaries. It is money that just keeps the business going. When that begins to decline, and many times it declines because of operational distress, it's a signal that you should be looking at for your client and for your own business. Declining working capital is normally a sign that either your business is doing badly and the margins are declining and therefore it's not generating enough internal flow of cash and working capital, or you are not reacting properly to competition, or you're cannibalizing on your working capital to invest in long-term assets, and that always results in a problem. When working capital dries up, you are facing insolvency. So that is a really important on the operational side. Now, operational distress is what is really early stress, and it that as insolvency practitioners or advisors into businesses, from a governance perspective, we should be on an ongoing basis looking at, because these are things that usually can be addressed early. And the way to normally look at it is any business, depending on the sector it is operating in, usually has about 3 or 4 levers that will determine its success. For example, levers will be first and foremost production, ability to produce the right widgets, the distribution. Once produce the widgets, be able to go ahead and pass widgets on to the customer. So distribution becomes an important thing. Third lever would be financial management, because there's going to be a difference in the production of the widget, the time the company receives from the widget. Timing has got to be managed. So, times if the company's business model is not being managed well, if they are not being managed, for instance, the production lever, are you checking, if it's a manufacturing company, are you checking that you are producing the right goods, and at the right place. Are you producing it at the right place? You should not overproduce it. It results in excess inventory, which again is a cost. So those are the systems you look at. Or over and above that, on the quality side, are you producing the right quality? The quality should not be too low, shouldn't be too high. It might be too expensive for the customer. So those are things you look at. Are there systems around that production element if you're dealing with a manufacturing business? So those are the things that you always look at. Now, usually when you have dysfunction in the business model, it's going to result in falling margins because many times you will not optimize the capital invested in. So that will result in falling margins. You will many times move away because your business model may have an element of customer relationship and you're not dealing with the customer well, or you're not meeting the customer needs in terms of your quality. It results in customer attrition. And then there is obsolete inventory. Now you're producing excess inventory and the market never stops to wait for you. The market keeps moving. So after a while, that inventory will eventually become obsolete. And obsolete inventory really is that huge amount of stock that you have produced at a cost, which over time is going to produce for you very little or no cash flow. And as I was thinking about how we organize our businesses as lawyers, it occurred to me that we have a lot of obsolete inventory. And if you're doing litigation and you have a whole lot of cases which are not producing for you the cash that you need. I'll give an example. Let's assume you have 200 cases. And from those 200 cases, you're only going to receive 50 million shillings over a period of 3 years. And you're servicing those 200 cases with 5 lawyers, each of whom you're paying, let's say 3 million shillings per month. Now, really, you're dealing with obsolete inventory. And you're really destroying your own business's value over time. So obsolete inventory occurs in any sector. And you have to be mindful of the issues around your business to assess what inventory actually is obsolete inventory for you. And then the other that I'll point out is also the supply chain failures. There'll always be a need to be able to access its market. And, you know, post-COVID, we saw just how significant the impact of supply. Now, the other indicator, which many times is the most difficult to address, is strategic distress. And this is the market. Because as I said, the market keeps moving. The market doesn't wait for you. The market has no passions. The market has no favorites. It'll just keep moving. So if your market share is beginning to decline, it means your ability to generate revenue from your business is going to continue to decline. So you will need to begin to look at that. The issue of technology and the disruption that's coming from technology, we've seen what's been happening in the banking sector, how the telcos stepped in and brought in fintech that has provided another alternative method of servicing customers from a banking perspective, payment systems. And now telcos, through mobile money deposits, are actually maintaining customer deposits, which is essentially a core part of banking business. So technology disruption creates disruption across the board. The telcos themselves are now being disrupted by what SpaceX is doing with Starlink. You know, so that's another disruption sector. When a business is not able to quickly reposition itself, then there will be distress in that business. This slide really we look at as distressed asset investors and what you can look at as an advisor to any business on whether that business can be turned around and what needs to be done to turn around that business. And there are really 5 key elements. The first 3 are most important. The first is a business that is to be restructurable, first and foremost, has to have a good product with a verifiable demand for that product. If it doesn't have demand for its product, it's a dead business. So you might as well begin to look at ways in which you're going to bring that business to an end or completely reposition that business at significant cost. It's going to be difficult to restructure that business in that situation. And many times, if we don't have that demand issue existing, as distressed asset investors, will simply not touch that business. The second element is whether the sheet can be fixed. And this is really what we look at. Is the business in a situation where if you take the debt that is falling due and you are able to convert it either into longer term debt or equity, the business will be able to go about ordinary course and generate liquidity. And for us, what we look at in those scenarios is whether the business has already invested significantly in its capital equipment, therefore in its ability to generate more widgets. So that's what we look at. If that is in place, then the balance sheet is flexible. You can always replace the debt that is falling due in something that is flexible. The other element is whether the cause of distress is something that is reversible and fixable. Now, one of the things that I keep telling people is you can be able to restructure operation. Operational distress is really around how you're going to deal with the leadership, how you're going to deal with bringing people who can execute, how you're going to be able to get the company real. Operational distress can restructure. The one thing I keep saying you cannot distress is the lack of integrity. If your client took on significant debt and diverted it from the business, marry a new wife, buy a new car to the business, that is something you cannot restructure. And we had a very interesting scenario, actually 2 scenarios, where we actually attempted to take on 2 entities that were, whose proprietors had, let's say, integrity issues. One of them was in the real estate space, and we thought, hey, you can always separate an individual from the real estate that he owns, and this business can be restructured. As we're working with the customer and working with the providers of funding, we realized that the integrity of the proprietor kept sabotaging our ability to move things forward. So integrity keeps. It is something you can't just erase. So whenever you're dealing with a client and everything looks right, but integrity is wrong, our advice to you is just step away from the client. The best you can do is just pray for the fella. The next item is on leadership. And one of the things that distressed asset investors will do, and we always do, is whenever we are taking a position with a company, we inform the business that we will take a hard hand on management. So we'll take the lead on management. And for us, the philosophy there is that the management that led the company to distress cannot be the same management that will lead the company out of distress. It can support of restructuring, but it shouldn't take the lead. So that's something that needs to happen, and many times it's a very difficult process persuading proprietors, entrepreneurs, that they probably need to take a back seat. So there's a lot of counseling that needs to be done. And the last lever is really, at the end of the day, cash is king. So if you're going to restructure, you need cash. If you think you're going to restructure and you do not have working capital for that business, you really are not going to restructure. What you're really doing is manage the death of an entity. So, and that really goes to how we do the restructuring. Last thing is make available working capital to the entity and manage the liquidity cycles. If the company has a very long timing difference between its passing out of the widgets and its receipt of cash, find a way of shortening that, because that creates internal liquidity. But there must be cash. Restructuring or insolvency practitioner or an advisor of any kind into this space should always look at the source of working capital for your business if you're actually seriously looking at restructuring that business. The other element, which I mentioned is extremely dicey, is how to improve the execution capacity of that business. And that spells by one word, it's leadership. Who are the guys who you're going to bring in who have a proven track record operating successfully in that industry, the industry where your client is operating or where your business is positioned to operate? So you need to deal with that leadership issue. You need to deal with the people who are in charge of those levers I told you about that every business depends on. So those are critical decisions you need to make. And the last one on the operational restructuring bit is how you're going to cut the fat out of the business, reduce the costs, and really rationalize them. And that many times is a very interesting decision, because there are investments that will be made by the business that are not maturing immediately, but will mature into the future. Now you need to bring that future forward in order for it to be relevant for you for restructuring purposes. And anything that is not adding sufficient value, and things like high salaries for you know, the family members who are also in staff, those things have to go. So that is a key element of the restructuring. The other element, which is also particularly challenging, is if you're in scenarios where you have to do a strategic repositioning. There's one particular who we had thought we had finished the full scale of negotiations with, really demonstrated this for us. We negotiated with 2 banks to buy their debt. We thought we had sufficiently negotiated with the client to take over their business. And when we now are on the verge of closing all the deals all around, the client tells us, you know, I am not comfortable with the approach you guys are taking. That take a completely different direction from what you guys are proposing to do. So that just, you know, took 8 months work back to square one. So one of the things, and it goes into what I'll show in the other slide, which is the fact that one of the key things that you have to do if you're looking at restructuring a business is go right back to the market. Work with the proprietors to get a real understanding of where they feel the business should be going, and then go and test that in the market. So there's a lot of market surveillance that would have to be done. You can't go around it, and it's extremely important. I've already talked a lot about the financial restructuring. When you have the two aspects of restructuring in place, the operational restructuring, you have a clear plan for that. The strategic repositioning, there's a key plan, there's a clear plan for that. The financial restructuring becomes much easier and much easier to achieve, because that's really about how you're going to rebalance the balance sheet, buy debt, convert short-term debt to longer-term debt. That becomes easier to achieve. Now, what are the red flags when you're advising in this space? What our experience has taught us is the major red flag is on the governance side. If there's a misalignment between the entity that is financing the restructuring, or the advisors to the restructuring, and the proprietors, you're going to have a really tough time restructuring that company. Actually, restructuring is more likely than not to just stop. And many cases, in that kind of scenario, you may want to backtrack from the restructuring and go into a different approach, probably receivership or, you know, some form of administration, because you are not going to be able to move the company forward in a non-insolvent restructuring scenario, which is really kind of the best kind of restructuring scenario, without the full alignment of the proprietor. So there's a little buy-in that needs to be achieved there. The next key red flag is on the market side. As I mentioned earlier on, you need to take the time and actually test the demand. We talked about the demand being one of the core features that we look at. The fact that there's a product and the fact that that product has. So the market is a vital thing. You cannot work on assumptions. And many times when you're restructuring, it's easy to go by gut feel. You'll think, this thing looks good. And obviously the proprietor will, urge you on and say, and after all, at some point X were doing very well. The reality is you have to test all the assumptions, because either your client or you yourself is going to ultimately invest money and time. So assumptions cannot be the basis upon which. So don't go for the market mirage, because you will get hurt down the line. The third red flag is creditor fragmentation. And it becomes a real challenge, because many times when a company is sliding into distress, the creditors, who many times are banks, become extremely greedy, extremely self-interested. And that is a natural thing for banks, because they lend money, they must recover that money, and they must recover that money selfishly. So you're going to have to find a way of demonstrating to each of the creditors that it's in their interests. And for a bank, their interests are really the fact that they're going to get their cash. So you need to demonstrate that they will get their cash with more certainty if the restructuring is and earlier. So you need to deal with that creditor fragmentation. If there are challenges around there, then the restructuring may fail. And the last, again, goes back to restructuring is driven by the availability of cash. There must be cash to drive the restructuring. That cash runway properly. Many times, what we have, based on the work that we have done and based on the entities we've been working with, for us, a 12 to 24 months is really the period of recovery that one should have. So for full cash, you really are talking of 12 to 18 months. So that is really what we look at. So how do you address these pitfalls? Governance, as I said, there's a lot of, this is where the advisors take off their hats as, hard number calculators or, legal advisors who want to just dwell on the law, and put on the advisors of counselors and people who can actually help to achieve compromise between yourselves and the creditors and the proprietors. It's key. That's a key thing that you need to do. You need to create milestones for the proprietors that align their interests to the interests of you as the restructuring person and the person who is financing the restructuring, and obviously the long-term debt providers. That's a key thing that needs to be done. Dealing with the stakeholders, at the time you're doing restructuring, it's important that the key elements of the business that make the business successful stay. And many times those key elements are resident in the human resource. So if it's a manufacturing business, there may be guys there who are really skilled. They understand the products of the business, and they understand how those products should be produced at the right quality. So you need to be able to communicate properly, have a communication strategy, an engagement strategy that preserves that, because that's real value. You lose that value, it makes it more difficult for you to achieve the restructuring. From the creditor side, many times when you have the alignment of the proprietor of the distressed business and you're engaging the creditor and demonstrating to the creditors of that business that you're willing to step in, many to listen. So you need to be able to negotiate arrangements among the different creditors that allow for the creditors to agree not to enforce while you're. And many times creditors, and particularly banks, for as long as you're negotiating a cash flow that doesn't exceed 12 months, they're willing to listen. They'll obviously negotiate hard, but I mean, they'll press you for 3 months, 6 months, but usually, if it's not going above 12 months, they are willing to listen. And market blind spots and the need to do the market analysis and ensure that you have the right mix. So I won't dwell in that. So I will really end with this because, as I said, I decided to position this really so that you as advisors will look at distressed scenarios, not as problematic scenarios, not as problem assets, but as investable assets. So as I mentioned earlier on, the largest banks in Africa collectively hold assets, and this is debts that they've created of over 1.4 trillion. The distressed component, the reported distressed component, is $126 billion across Africa. In Uganda, the reported distressed component, which is NPLs and written off in the last 3 years, is in excess of $1.5 billion. And that is only what is reported. So the unreported takes it to much higher. Now, in all of this, what does it tell us? These are businesses that have the ability to be turned around, that have the ability to continue to contribute meaningfully to the economy, to employment, and to growth. They have the ability. But lawyers have to begin to look differently at these businesses. And it's not just the lawyers who are in the insolvency space, but lawyers across the board. If you're in the governance space, governance should not be simply about ticking compliance checks and taking minutes and advising at the board. It should go much deeper. It should go into assessing what is really happening to the business. You've been sitting in the boardroom over the last 3 years and the business is steadily losing market share. That is a sign of distress. What are you doing about it as a governance professional advising the board? If you're a transaction advisor and you know your client who is going to a bank to negotiate, and the bank is negotiating hard for very hard liquidity ratios, a current ratio that is much higher than what you know your customer, your client can achieve. It is in your interest. You're supposed to know your customer's business. So it's in your interest to negotiate for your client, understand your client's business, understand what your client can do, and then do that negotiation with the bank to achieve your client's objectives. Because your client, many times, as a businessman, will just want the cash. So at some point X, he will stop negotiating and he'll just take the cash, regardless the kind of covenants that are being thrown at him. And then obviously, from the insolvency perspective, for as long as you're looking at the assets as investable assets, there is so much more that you can do. It won't simply be about managing a business for recovery or for creditors, but it will be more about how can we recover for the creditors, but keep this business not just alive, but take it to a point where it can thrive. Thank you.
Amazing. My own class. Thank you very much, Mr. Ogwal, for a wonderful presentation. We will, before we react and share through the questions, we will take a 5-minute break, and that's to allow our attendees to have a health break and also our IT team to perfect the microphones. We have had a complaint from the chat about the unreliability of that. So let's just fix that. And in the 5 minutes for the rest of the class and the attendees, please share through your question in what has been presented and also your reaction to the presentation. We'll take time to read through and have Mr. Ogwal answer a couple of them as we proceed and transition to our last panelist for the day. Now. Microphone testing.
So the signal is just behind now.
That won't be an issue. That's better than here because our backs are against the signal.
Testing.
It's
Testing.
going to be better. Okay. We might need to
Testing.
also test Council Nelimas and just do the testing.
Testing. So I shouldn't move, eh? I should just.
This is behind now.
Hopefully it won't be an
Closer
issue.
they
Fine.
just brought.
Right. Yeah, so there's something there that needs to be done. I am not sure our regulator is willing to do this. I don't think so. Our regulator is very.
Welcome back from the health break. And we want to echo our thanks to our presenter, Mr. Ogwal. Thank you very much for a very insightful presentation. We have questions coming in. We still have time for more. So if you have a question, please make sure that you send it in the chat room and we'll be able to see it and read it. But the first question comes from one of our panelists, Council Nelima, in reaction to the presentation and also one of the things that are rising in the subject that Mr. Ogwal was addressing. You have the floor, Council.
Thank you very much, moderator. Thank you very much, Joshua, for the wonderful presentation. My question is about asset reconstruction and asset reconstruction companies in particular. I'd like you to share with us the role which asset reconstruction and asset reconstruction companies can play as an approach to distressed assets, especially within our jurisdiction. You've mentioned that many of the creditors here are banks. I believe we shall greatly benefit if you share your insight about asset reconstruction as a viable approach. Thank you.
Thank you very much. I don't know if you favor to answer one by one or we can have all of them and you answer at once.
What I could do, because Nelson has asked a very interesting question. I think let me first deal with this question and then we'll go to the next. Now, the role of ARCs is to a large extent dictated by the state of regulation in the banking sector. Our regulation in the banking space is such that the banks are effectively required to lend short-term and recover as quickly as possible within a space of a year, because for as long as they are faced with default or potential default, the regulation requires that they start provisioning. Now, provisioning means they're essentially taking from cash that they would have reported as their profits and covering a potential capital gap. Now, for banks and for the shareholders of banks, that's a serious issue because it affects the earnings directly of the shareholders of banks. So, because of this approach to regulation that forces banks to think fairly short term, which has its own basis, and I don't mean to criticize it, it has a very strong basis and it is relevant. But because of it, it means that when businesses are going through cyclical distress, which is many times distress that they can come out of, distress that can be restructured, then they don't get the kind of support that they need from banks because regulation does not allow the banks to do it. If a bank wants to restructure a company, it has to provision before it restructures. So there is no benefit to the bank to do the restructuring. The ARC in that scenario, or ARCs in that scenario, comes in to remove this debt from the regulated banking environment and take it into a less regulated environment where there's a greater ability to do the restructuring and then achieve cash flows in the medium term. And medium term really means 12 months to 36 months. Now, why is this particularly important? We have all seen a lot of situations where, because of transition, and we're seeing it quite a bit as we operate in the market, where because of transition in generations, businesses die. We had a very recent and extremely unfortunate case of BMK, the empire that was doing extremely well, set up by a truly visionary entrepreneur, and he passes on, his empire, collapses. And this has been the African story. And many times it really is because, although the entrepreneur is visionary and he set up this business, at the time transition is supposed to occur, he does not take the opportunity to look at himself apart from the business. So the business, the operational distress issues that we're talking about begin to occur. The proprietor gets older, he's not attending enough to the business, he gets his sons in, the sons are not as aggressive as he was in business. So operational distress begins to occur and it just gets worse and worse and worse. And eventually when he dies, the business goes into outright default and eventually dies. So that is one thing which makes it particularly important for the Ugandan context. So ARCs are important for the Ugandan context. They play a role and they do not replace, they are not intended to replace banks. Banks will continue to do their business. The ARC is only coming for that medium-term period where they nurse the company back to stability and then send back the company into the banking space. So that is really the role, as we see it, of ARCs. But thanks for that question. It's a really good question.
Amazing. And just to pass the baton on the same question, most of the times, and in your experience, especially at Rikindo, you realize that the reality of the market is that, of course, financial institutions will be most of the creditors. And their cooperation is very important for whatever that you are trying to do in terms of not sinking. And this is the patient that has been presented to you, is in ICU. You want to put them on intensive care, but the heart belongs to the bank, which is like the biggest debt. And you have a bigger responsibility to convince this financial institution that instead of realizing the mortgage, please give me a chance to maybe help stabilize things here. Are there limitations, or is your case worse because of the policies by the regulator like Bank of Uganda, as opposed to, for example, in terms of the expectations on those financial institutions and what targets they have, which makes it harder, for example, for financial institutions to play along in the strategy that you would have laid to ensure that the distressed assets are in that kind of story, in your experience?
You've asked an unfair question with a lot of landmines, because now I have to tread very carefully so that I don't anger some of the stakeholders that I deal with, the commercial banks and the regulator. But this really is the reality. When a debt goes into distress in a bank and the bank has begun to provision for it, what the bank is really looking at is recovering its money as quickly as possible. And many times, and this also is because banks, the way they operate is from time to time in silos, so you'll have the finance department that is really managing, the CFO and the CEO who are managing the balance sheet and seeing that there is profitability. And then you'll have the workout unit which just wants to recover as much as possible, as quickly as possible. So because they have that siloed mindset, many times when you're approaching the workout unit or the credit unit for purchase of assets, they are looking at the asset for its nominal value. So if, for instance, they lent $10 million, they want to recover $10 million, and the guy's bonus is pegged to that recovery, so he should recover $10 million. But the reality is that the bank has already provisioned for that asset, and probably in its books, the provisioning is already about, let's say, $5 million. So if you are to help the bank resolve and pay them $5 million, they'll also release provisions of $5 million. So there are those realities. But also, many times the banks, in some instances, will not look at the fact that by holding this asset in-house, they are actually spending money. They are, for one, spending money on their teams trying to recover, salaries and management time that is being spent on recovery rather than being spent on underwriting good assets. But also, to the extent that they are holding this money and not recovering quickly, and many times debtors are more aggressive because they want to save their business, particularly when they believe that their business has the ability to turn around. So they will fight. They'll fight in court. They'll do whatever it takes. And that will bring in the element of the devaluation, the time value of money which the bank is losing. So part of what we have to do when we are engaging banks is persuade them that it's in their interest to let go of this asset quickly. And obviously we discount the debt because we take into account all the factors around the debt, the timing of cash flows to us, how long it's going to take for us to recover the money, what money we're going to have to invest to recover the money we're buying. So we discount the debt, but we have to persuade them that that discount still gives them good value because they'll be able to invest that money in underwriting good credit, and they'll also be able to release provisions that they're already holding. So those are the things that need to be done. Now, what can the regulator do? In some instances, what regulators have done, and many times this is when asset management companies have been set up by governments or by the regulators themselves, is they have provided a form of moratorium where they have said, for as long as the bank is dealing with the asset management company, they don't have to provision any further if restructuring is going on. So they've actually been those instances. Or there have been instances where they've allowed scenarios for the bank to pass on these distressed assets to the asset management company and then get paid over time without any penalties hammering their capital. So there are a couple of things that the regulator can do to allow for more uptake by banks to these products and to allow for companies that they are managing to, in their portfolios, to be restructured by AMCs.
Wow, amazing. Thank you very much. We have one question from Arnold Lule Sechiwano, and he's saying, thank you, Joshua. And he asks, is there any role that capital markets can play as far as distressed businesses are concerned? And he also asks, what has been your experience in this regard, and what solutions have you recommended for your clients? Are there some examples that you can share from your experience?
Now, capital markets. Capital markets are absolutely vital in a distressed asset sector, because it's through the capital markets that you get alternative capital. Now, as Rekindle, part of what we did in order to be able to restructure businesses is we set up a fund and have had to get commitments from other alternative financiers into the fund in order to be able to finance distressed assets. So we're not getting our money from commercial banks, we're getting our money from alternative financial institutions. So alternative financial sources. So capital markets are extremely important. And part of what ARCs are really doing is deepening the capital markets. Anytime you have a product that allows for finance to be raised other than from commercial banks, you're actually helping to deepen the capital market. So our financiers are entities that don't have licenses to provide financing as banks, but they have significant amount of capital. Also, part of the groups that we deal with are actually individuals who have put aside enough cash that they're willing to invest in products of this nature. So it allows for us to pool that capital and then make them available for these distressed assets, obviously in a structured way that preserves the value of that capital. So that's a good question, and indeed we are benefiting. We are helping to grow and deepen the capital markets, but we're also benefiting from the fact that alternative sources of capital exist, and they're only looking for an appropriate intermediary, and better still, a regulated intermediary through which their savings can be passed on to a financial product.
Thank you very much. We have 5 minutes and 5 questions, so this will be more of a quick fire, short answers for these, maybe in a minute. Mr. Muhammad Bazilengede is asking, what would happen to a mortgage of a liquidated company after closure of the office of a liquidator? That is, of course, aside what you are discussing, but in the event that the mission to rescue this fails, but you have to now go into liquidation. He's asking what would happen to the, for example, mortgages of a liquidated company.
Well, if obviously mortgages, if you are, now I'm assuming that he's talking of a scenario where the company that is under liquidation has mortgages on its assets. Yeah. So really what happens in that scenario is a mortgage is a fixed charge. So a fixed charge has priority over other charges. So really the mortgagee would have the ability to enforce their mortgage and get paid out of those mortgaged assets. So those mortgaged assets wouldn't really be, the cash flows from those mortgaged assets wouldn't really be controlled by the liquidator. They would be held by the receiver of the mortgagee, because that they have priority. So that's something, and maybe the receiver can work alongside the liquidator to ensure that there is an organized process for the liquidation or the enforcement of that mortgage. But the cash flow goes to the mortgagee. So that would be the simple answer to it. But again, if I'm to bring in the ARC perspective, we usually do not deal with insolvent scenarios. What we would do is, if there is a receivership, then we can come in to support the receivership purely from an asset management perspective and a financial management perspective, providing finance only where it is deserving and where there is the receiver is able to demonstrate that this is a company that has been put into receivership for technical reasons but can be restructured and operate profitably.
Thank you very much. Mutumba Collins thanks you for the free legal advice, especially on obsolete inventory in the law firm. I think he's counting his lawyers and how many cases that he has. There's a question from an anonymous attendee who's saying that with the 2022 amendment, are you seeing meaningful uptake for PCF in Uganda? And more broadly, from an investor's perspective, what are the main legal constraints still holding back a distressed debt investment environment in Uganda? I don't know how quickly you can answer that.
Maybe just a quick thing on that. The 2022 amendment was really meant for mortgage refinance entities. It's not so much for the benefit of AMCs, which are short-term. Asset management companies are really meant to be short-term, short to medium-term vehicles, while the mortgage refinance companies are supposed to be looking very long-term and essentially buying assets for banks to make liquidity available to them to own, lend, and create more mortgages. So they are really meant for different purposes. I hope I've gotten your question correctly.
This is feedback and comments by one of the attendees, Kisale William Nicholas, who's saying distress affects several stakeholders on insolvency, some of them shareholders of financial institutions or investors. Their rights seem to be overlooked during insolvency, and the law seems insufficient to address the shareholder rights, as indicated in the several cases in courts that have never been disposed of. As a resourceful person, what are the possible modalities to address shareholder issues?
Now, shareholder issues, as I mentioned, what we generally do is, from an asset management company perspective, we prefer to deal with entities before they go into insolvency. And I mentioned that one of the key things that we look at is alignment with the proprietor. So for us, it's important to ensure that the shareholders are aligned to us. And what we actually do is we appeal to their selfish passions. They invested their money as shareholders so they can make money. And what we're telling them is, look, we are coming in to invest alongside you so that that value that is locked in the company, we can help you get back. And thereafter, and we are going to be out of here in 3 years. Thereafter, you'll have a more valuable company and you can do whatever you want to with it, and you'd be able to sell off the company should you choose to at a higher price.
Thank you very much. That brings us to the end of a very insightful and deep presentation and Q&A session by Mr. Joshua Ogwal. Thank you very much for making time. Send our regards to LegalMark and Rikindo. Please, may you grow. We send you blessings. Yeah, thank you very much for your time once again. So we are heading into the last presentation for the day. We are right on the dot. We started 10 minutes after time, so we are right on time at 11:40. And the next presentation will be by a person I've already introduced, an expert in the area by the names of Counsel Nelima Nelson, on effects of insolvency on corporate personality. This is as opposed to individuals. And this is a fascinating topic because it touches on the intersection of insolvency law and company law, where the presenter is an expert, and above him there's no other authority beyond the legal doctrine, but it's also practical consequences. Of course, he will share on directors, shareholders, creditors, and insolvency practitioners. The abridged CV of our presenter is that he's a partner and senior advocate at Nambale Nelima and Company Advocates, and is also an insolvency practitioner. And he's been in private legal practice, so it was not a joke when I said I hadn't done my PLE, because he started in 1998. The professional overview is that he's a seasoned private practitioner and certified insolvency practitioner with over 2 decades of active litigation and corporate advisory experience. In addition to his legal practice, he's an accomplished academic who spent over a decade lecturing at the Law Development Center and has authored leading regional textbooks on Ugandan company and insolvency law. The moderator is a beneficiary of those projects. Mr. Nelima has also authored other textbooks, including Practical Guide to Company Law in Practice in Uganda, as I've just mentioned, also Uganda Insolvency Law Handbook, and Essentials of Uganda's Employment Law. So ladies and gentlemen in the room, without further ado, let's give our participation and use your clapping emoji as we welcome Mr. and Counsel Nelson Nerima. You're welcome, sir.
Thank you very much, Harold, for the very kind words of welcome. I thank the Uganda Law Society for once again organizing this Insolvency Law Training. I am not here as an expert. I am here as a member of the Uganda Law Society who would like to share some perspectives with colleagues in the legal profession. Many of the things I'm going to talk about, you've heard of them. My intention is not to educate you about these concepts, but just to tickle your intellect so that you can look at these concepts in a different light and also in light of the evolving legal landscape. So in the next 1 hour or less, I will talk about effect of insolvency on corporate personality. As the moderator has said, this topic explores the intersection or the interplay between company law and insolvency law as far as companies are concerned. Of course, we start by looking at corporate personality very briefly. Yes. So as we all know from our undergraduate legal training, corporate personality will be found in our Companies Act. And once a company is incorporated, to remind ourselves, there are a number of effects which I can summarize as follows. When you read Section 3 of the Companies Act, upon a company being incorporated and a certificate of incorporation being issued, this company becomes a body corporate, number one. And when it's a body corporate, it can exercise all the functions of an incorporated company. And as we all know, the functions of an incorporated company are limitless. Anything, most things which a human being can do, legally, a company can also do, with a few exceptions. In his or her wisdom, the draftsman specifically included that a company can hold land. Although, as we know, an incorporated company generally is a person, so it can hold the land. But specifically, they mentioned it can hold the land. Later on, we shall see what holding land capacity entails when there is a liquidator. Then, of course, there is perpetual succession, meaning even if the shareholders or directors die, it does not affect the corporate personality of a company. Even if all the shareholders die, even if all the directors die, the company will remain. Then, of course, it has a common seal, and lastly, there is limited liability of members. These are some of the most important incidents of corporate personality. Yes, now, when we move on to corporate insolvency, there are 4 main methods of placing a corporate body in insolvency proceedings, as we all know. we have receivership, we have provisional administration, we have administration, then lastly we have liquidation. So now we are going to briefly see how does receivership, provisional administration, and liquidation affect corporate personality under the Companies Act. We shall start with receivership. We shall not define what receivership is. I'm sure you know, and if there is need to go deeper into that, that can be a discussion for another day. But once a company is in receivership, that receivership has certain effects on corporate personality, which we've seen above. One, the receiver has custody and control of all property under receivership. When we go back to corporate personality, we saw that a company can exercise all functions of a company and it can hold the land. However, when a company is in receivership, the capacity to exercise all functions of a company and also to hold the land is in a way curtailed, because as far as the property under receivership is concerned, the company will cease to have custody and control. The company will retain ownership, however, custody and control is in the hands of the receiver. Secondly, registration of all land and other assets under receivership is in the name of the receiver. In the wisdom of the drafters of our Insolvency Act, when a receiver is appointed, he or she has a right to register the assets under receivership in his or her name. Later on, we can hear the views of members whether this is necessary or even wise. Must you be registered as proprietor of a property in order to exercise powers and functions of a receiver? But under our law, the receiver has power to register assets under receivership in his or her name. 3, the receiver can demand and recover by action all income of the property in receivership. We know that a company has a right and capacity to sue and collect debts in its own name. But we are now seeing that during receivership, the receiver can demand, not in the capacity of the company, but in the capacity of receiver. He can demand and recover. Then we have a category of receiver called administrative receiver. This one can carry on the company's business, manage the company's property and affairs, and perform any function or power that the company or its directors or secretary would perform if it was not in receivership. We know that in company law, the business of a company is managed by the directors. That is basic company law. But we are seeing that if there is an administrative receiver, he or she is the one who manages the company's business. And of course, when there is an administrative receiver, he or she can change the company's registered office or registered postal address. During receivership, the company may only bring an action with the consent and approval of the receiver. This is also found in our Insolvency Act. So if a bank appoints a receiver over all or certain assets of the company, any action in respect of that property or that company, depending on whether the receivership is for an asset or all assets, requires the consent and approval of the receiver. And the company must establish a prima facie case and furnish security for costs. There is an interesting case, Sudiri Pareria versus Korean Bank in receivership. I'm sure it will be discussed tomorrow in the session on interplay between insolvency and financial institution, where the commercial court made a landmark decision that a financial institution in receivership lacks capacity to sue. Yet, under the Companies Act, it is a body corporate, but they are now saying it lacks capacity to sue. That's the current interpretation of the law. Briefly, that is receivership and its effect on corporate personality. We shall now look at provisional administration. We shall not try to define provisional administration because I'm sure members are familiar with provisional administration. We shall concentrate on the effect of provisional administration on corporate personality. Under the Insolvency Act, Part 6, during provisional administration, a company shall not exercise any of its functions or powers. Let's first break that down. It's very wide. A company shall not exercise any of its functions or powers. What does that mean? Does it mean that during provisional administration, all the powers and functions of a company under the Companies Act come to one end? What does it mean? A literal reading of the provisions would mean that when you are under provisional administration, all your powers and functions come to an end. That is the literal reading, but I think it would lead to absurd results. Otherwise, there will be no company in provisional administration. So we shall benefit from the views of the members and maybe from future court decisions. What does it mean when it says a company shall not exercise any of its functions or powers? One interpretation could be that when they say a company shall not exercise any of its functions or powers, that the draftsman meant that the organs of the company, i.e., the shareholders and the directors, will not. But the intention was not that the company itself. So I think the intention was that the shareholders and directors shall not exercise functions or powers during provisional administration. Then, of course, a company's directors and secretary shall not exercise any powers, functions, or duties as such, except with the administrator's approval. So a reasonable interpretation would be that the context of the provision is to curtail the functions and powers of the directors and other officers of the company. And they cannot exercise any powers except with the administrator's approval. Now, that was provisional administration. When we go to administration itself, the Act, the Insolvency Act, does not lay down any detail of what the directors and shareholders can do or cannot do. It only talks about an administration deed. That the administration deed shall bind the company, the directors and secretary, the shareholders, the administrators, and all company creditors in relation to claims arising on or before the date specified in the deed. Therefore, when it comes to administration, the limitation or curtailment of powers and functions of a corporate body and its officers is not found in the Act. It is found in the administration deed. So when an administration deed is being drafted, there will be a bargain with the creditors on how much power and function should be left to the company and its shareholders and directors, and how much power should be exercised by the administrator and how much power should be exercised by the creditors. So it is a balancing act, give and take, and when they reach a compromise, they draft an administration deed. So it is very clear from the law relating to administration that when a company is placed in administration, obviously there might be an effect on corporate personality and the incidents of corporate personality. But the extent of the effect is subject to a negotiation or compromise in the drafting of the administration deed. Let us now go to liquidation, which is another proceeding in insolvency. We all know what liquidation is, and if we need a refresher, that can still be a topic for another day on procedure. For our current purposes, we shall concentrate on effect of liquidation on corporate personality. Of course, we know the types of liquidation. There is members' voluntary liquidation, creditors' voluntary liquidation, compulsory liquidation by the court, and so on. Now, briefly, this is what our law says about effect of liquidation on corporate personality. One, our act says that from the commencement of liquidation, the company shall cease to carry on business, except so far as may be required for the beneficial liquidation of the company. We saw at the beginning that when a company is incorporated, what can it do? It can exercise all the functions of an incorporated company. But now the Insolvency Act is saying that once the shareholders pass a resolution for voluntary liquidation, the company shall cease to carry on business. What does this mean? That one of the benefits or incidents of corporate personality is lost or curtailed. The moment you decide to commence voluntary liquidation, you must cease to carry on business, except as may be required for the beneficial liquidation of a company. There is some business which is permissible. For instance, if it is a supermarket and you pass a resolution to wind up, does it mean that you allow all the goods in the supermarket to expire? Of course, no. You are allowed to sell the stock and clear it, but you do not order new stock, but you sell existing stock. If you are running a school, you can decide that let us wait for the children to finish the, yes, or to finish the term before we stop. So that is what we mean by continuing business which is required for the beneficial liquidation. Now, I also note, and you will note, that our Insolvency Act refers to liquidation. But when you go to the Companies Act, Part 9, it refers to voluntary winding up. So, what is the difference, if any, between liquidation and winding up? There is an unfortunate interchanging of these terminologies. Liquidation, winding up. Now, still under the Insolvency Act, Part 4, the corporate status and powers of the company shall, notwithstanding anything to the contrary in its articles, continue until it is dissolved. This is a remarkable provision in Part 4. On the one hand, as we've seen and as we are going to see, Part 4 is curtailing the power of the company to do business, the powers of directors, the powers of shareholders, but at the same time, Part 4 is saying the corporate powers and status shall continue. But is that true? It is actually not true. The general provision is the corporate status and powers shall continue until dissolution. But it is actually not true. when you read the details in Part 4, the corporate powers and status are actually greatly curtailed. Maybe the company continues to exist as a body corporate, but when it comes to the powers, very little is left during the process of liquidation. For example, Part 4, at the commencement of liquidation, the liquidator shall take custody and control of the company's property. How would you reconcile that with the other provision, that the powers and status continue? Of course not. Liquidator takes custody, meaning the directors and other employees have no power to have custody. The officers of the company remain in office, but cease to have any powers, functions, or duties other than those required or permitted to be exercised by this act. So we have a situation where the directors, the company secretary, remain in office as directors and company secretary. However, they don't have any power. Yes, which is a strange occurrence, that you are in office, but you don't have any. I don't know how it works, that someone is a minister, but he doesn't have any powers of a minister. Or that someone is an MP, but he doesn't have any powers of legislating. So this is how the act is worded. You remain in office, but you don't have any powers, functions, or duties, except those required or permitted by the act. When you read the act, you find that the so-called duties are about to cooperate with the liquidator, that when it demands for information or records, you hand them over. I don't know if that is a power. Maybe it is a duty, but it's not a power, or an obligation, that when the liquidator asks you for information or for documents, you must hand over, you must comply. Another effect is that proceedings, execution, or other legal process shall not be commenced or continued, and distress shall not be levied against the company or its property. This one is very well known to lawyers. Many times when a company is facing a suit, and then someone applies for liquidation, counsel will say, "My lord, a petition has been filed in civil division for liquidation of this company. I pray that the proceedings of this suit be stayed." The company is still a body corporate, but proceedings cannot be commenced, and those which were commenced prior cannot be continued. So what happens if the liquidation petition lasts for 3 years? And there are petitions like that. They are under constant adjournment with a view to settling or finding money to pay. So what happens to the pending suits? Someone was asking me one time, are there exceptions where the court can allow the legal proceedings to continue? In my view, it is possible to get leave of court, because the court has control over the liquidation. So in my view, the court where the liquidation petition is pending, I think, has power to authorize that let either execution or a civil proceeding proceed with the hearing. I think the court retains jurisdiction, but I'm open to the views of other members. Another effect during liquidation, shares of the company shall not be transferred. So when you are in liquidation, shares in that company cannot be transferred. You can see that in company law, Shares are movable property, which can be transferred. It is an incident of corporate personality in company law. But once liquidation commences, the company loses that power or privilege. Shares in that company cannot be transferred. Alteration of the rights or liabilities of a shareholder cannot be done. A shareholder cannot exercise any power under the memorandum and articles of association when a company is under liquidation. So we can see that whereas in company law, shareholders have power in the memorandum and articles, once liquidation starts, shareholders can no longer exercise any power. So again here we see that powers of shareholders in a company are curtailed. And the moment you curtail powers of shareholders, you are in a way curtailing corporate personality, because in corporate personality, shareholders have certain powers. Memorandum and articles of the company shall not be altered. A company has power to alter its memorandum and articles under the Companies Act. But during liquidation, the memorandum and articles cannot be altered, with the exception that only the liquidator may change the company's registered office or registered postal address. We do not have time to dive deep into this case, but it makes very interesting reading. This one was about a sale of assets of a company in liquidation. The case was decided by the Supreme Court some years ago, but the liquidator applied for review of the judgment on the ground inter alia that it contained errors apparent on the record. The Supreme Court agreed to review the judgment and made a number of pronouncements about powers of a liquidator, generally, and powers of a liquidator to sell company assets. The original Supreme Court judgment had suggested that there is a need for a special resolution of the company to sell assets even during liquidation. And the Supreme Court said that was a wrong holding. For as long as there is a liquidator, he has power to sell without a resolution. So I will encourage members, when you get time, you can read that landmark case of Henry Wambuga, liquidator of African Textile Mills Limited in liquidation, versus Rancho Dubai, Shivabai, Patel, and Mokwano Enterprises Limited. Supreme Court Civil Application number 42 of 2021. It was decided on 10th September 2025. It is available on ULI. If you don't have time to read it from beginning to end, you can use the AI to summarize it for you. Yes. So I will encourage members to read that decision. Another effect of insolvency, in particular liquidation, is that there is power to pool assets of associated companies or to lift the veil. We all know that a company is a separate legal person from its shareholders and directors. However, during liquidation, the liquidator has power to apply to court to pool assets of associated companies, which are separate legal entities, but their assets can be pooled with the company under liquidation. When you find time, as far as lifting the veil during insolvency is concerned, you'll kindly read the case of Uganda Revenue Authority versus Crane, Autos, and others. Commercial Court Miscellaneous Cause number 26 of 2024, where Justice Mubiru allowed an application by Uganda Revenue Authority to lift the veil of a company under liquidation, and to hold its directors and shareholders personally liable for tax obligations, and also to hold associated companies liable for tax obligations of the company which was under liquidation. So this is a direct effect of liquidation, i.e., lifting the veil and pooling assets of associated companies. Now, before we leave liquidation, it is important to briefly discuss dissolution, because receivership does not bring a company to one end. Provisional administration does not bring a company to one end. Administration does not bring a company to one end. However, liquidation brings a company to an end. And this is what we call dissolution. So one effect of liquidation is the company is dissolved after the liquidator has filed the final return. And after the liquidator has filed the final return, the registrar or official receiver will issue a certificate of dissolution and remove the company from the register. Now the question is, when does the company come to an end? Does it come to an end by operation of law when the liquidator files the final return? Because the Act says when the liquidator files the final return, after some time the company is dissolved. So the question is the company at an end or dissolved by operation of law, or it comes to an end when the registrar removes the company from the register? Because there are two things here. The law talks about dissolution after the final return, and then it talks about the registrar removing the company. So, if a company has been dissolved by operation of law, but it still appears on the register, is there a company or there is no company? Someone may argue that removing from the register is just a tidying exercise, that it's a mere, yes, that if a person has died, but there is no death certificate, does it matter whether or not he's still on the register of birth? Maybe it does not. But another person can argue that unless and until the company is removed from the register, it still exists as a person. Personally, I would prefer the former interpretation, that once a company is dissolved by operation of law after liquidation, even if it still appears on the register, there is actually no company in existence. It has ceased to exist. Now, let us briefly look at civil litigation or civil procedure. We have seen what the Companies Act says about a company, that it can exercise all functions of an incorporated company. And we all know that since an incorporated company is a person, it can sue or be sued. When we come to civil procedure, especially Order 24, Rule 6 of the Civil Procedure Rules, it provides, and I'm summarizing and paraphrasing, the insolvency of a plaintiff shall not cause the suit to abate. Meaning, if the plaintiff is a company, and the company is under insolvency, i.e. liquidation, the suit does not abate. Therefore, it would be incorrect for counsel to pray that the court abates the case or dismisses it merely because they are liquidation proceedings or insolvency proceedings. The rules say the insolvency of a plaintiff shall not cause the suit to abate. So the suit remains. Order 24 Rule 6 also provides for a scenario where the assignee or receiver neglects or refuses to continue the suit. It can happen that a company is in insolvency, i.e. liquidation or receivership, and the receiver or liquidator refuses or neglects to continue the suit. In that instance, the defendant may apply for dismissal. Why? The liquidator or receiver, as the case may be, has neglected or refused to continue the suit. We are now going to summarize the effects of insolvency on corporate personality. This is a very quick summary. From what we've seen, when a company is undergoing insolvency proceedings, the effects are the following, i.e., there is an effect on the powers of the directors and secretary. And when you are advising a client, it would be important to always summarize for them that if they decide to proceed under insolvency, they must understand the effects. Many times, we legal advisors know a lot, but we do not advise the client. You only advise on the benefit that maybe if you go under provision administration, you'll get breathing space. But then you also don't advise on other things. For instance, what will happen to your powers as directors? So it is important to give all-around advice so that the client can make an informed decision. So, powers of directors and secretary are curtailed during insolvency. Capacity to hold property is curtailed. We've seen that in receivership or even in liquidation, the liquidator can register properties in his or her name. Capacity to sue and be sued is curtailed. Power to carry on business is curtailed. Lifting the veil is enabled. The legal existence of the company itself comes to an end. When the company is dissolved. And then lastly, an effect of insolvency is the company will be removed from the register. Now, there is something which is similar to removal from the register. This is called striking off. I have not gone into striking off because striking off is not an insolvency proceeding. Striking off is under the Companies Act, and it is very controversial. When a company is struck off the register, does it still exist or it does not exist? That can be a discussion for another day, or members can offer their perspectives. But in summary and in conclusion, the final effect of insolvency on corporate personality is the company as a person will cease to exist. So briefly and in summary, that is what I had to share regarding effect of insolvency on corporate personality. I will now be happy to answer questions and also to listen to the comments and contributions of the audience. Thank you very much.
Amazing. Thank you very much, Councillor Nelima. Very, very perfect summary. You have, I know you are humble enough to say you are just sharing your contribution, but thank you for the lecture. And it was very, very insightful. Before we receive questions, we have set for you self-assessment questions from Councillor Nelima's question. You can answer in your heart of hearts. And the first question is, does insolvency alter a company's separate legal personality, or does it merely change how the company is managed and controlled? 2, you will answer to your managing partner if they have paid your fees for today's session. At what point, if any, does the doctrine of separate corporate personality become less significant during insolvency proceedings? And finally, our last self-assessment question from the presentation: how should one reconcile the principle of separate corporate personality with the need to protect creditors? And I know if you have been paying attention, you are able to have answers to those questions, but we will proceed to take and ask Council Nerima to give answers to some of the questions that we have received. And Council, with your permission, if you have had a breather to take a sip on water. The first question comes from Martha Nalubo Wabirungi, and she's asking, upon taking over the company as a liquidator, and there is need to dispose of the shares, must the liquidator be registered as a shareholder first? How can such shares be disposed of by the liquidator to the purchaser of the same?
It's not very clear whether she means shares owned by the company in another company or shares in that particular company, because shares in that company are owned by the shareholders.
That's true.
As we all know, shares are movable property. I think that is section 81 of the Companies Act. Shares are movable property, and it is the shareholder that owns those shares. So the liquidator cannot sell someone's shares in the company. That would be unconstitutional.
I think to sanitize the question, assume that we are liquidating, for example, a company that had shares in another company, which would be an asset of that company under insolvency.
Yes.
Maybe how would that be treated in light of question from Martha?
Because when you are a liquidator, your duty is to collect all the assets of the company and liquidate them. Naturally, if this company holds shares in another company, the liquidator has power to sell and transfer those shares. But with respect to shares in the particular company under liquidation, as we saw, during liquidation, there cannot be any transfer of shares. So even the shareholder himself or herself cannot transfer. The reason is simple. In liquidation, there are what we call contributories. These are persons who are liable to contribute to the assets of the company during liquidation. So if you are a shareholder and you did not pay for your shares in full, the liquidator will
First demand.
Yes, like a call on you
that's
to
true.
pay up. So it would be difficult to follow up contributories if we allow shareholders to sell or transfer shares. The reason is to pursue shareholders who are contributories. Either you didn't pay at all or you pay it partially. So the liquidator is always given leeway to pursue contributories. That is why the law restricts transfer of shares in a company under liquidation. I hope I have answered the question.
I think that is very clear. Thank you very much. If you seek any clarity, please do not hesitate to do follow-ups in the comments section. I'll be able to address them to our panelists. We have a question and a comment. It's both seeking clarification from Mugoya Musa, and is asking, saying that there seems to be some contradictions in the principles. While under receivership, the receiver has custody and control over the assets, but ownership remains the company's. However, by requiring registration of all assets such as land in the names of the receiver, its effect could be that ownership passes from the company to the receiver. Kindly clarify.
Okay, thank you. As we all know, receivership is not ownership. Receivership is just a mechanism for recovery. That you fail to pay back a loan to the bank, and the bank appoints a receiver, either to manage the property and recover the money or to sell the property. And as we all know, once a mortgage, always a mortgage. Usually a receivership is under a debenture or a mortgage. So you cannot turn a security into ownership. So a receiver or the person who appointed the receiver is not the owner. He or she might be registered as an registered proprietor, but the purpose of that registration is not to make the receiver owner or to make the bank the owner. The purpose is to facilitate collection of the debt.
And then remit to the financial institution.
And then remit to the financial institution. Otherwise, it's not to assert ownership, but just it's a security interest. So it would be wrong for any receiver whose name has been entered on a title to assume that they are
they have powers to deal with it otherwise.
As they wish. It is like an administrator of an estate being registered on a title. Is that administrator the owner? No. It's like a trust relationship that you are holding it in trust for the beneficiary. Similarly, the receiver's duty, he owes his first duty to the creditor to recover the creditor's money. If he is able to recover from the income, then he will transfer the property back to the company. If he is unable to recover from income, he will sell, recover the sale proceeds and pay them to the creditor.
The creditor.
In this case, the company will never get back the property. But the bottom line is that the registration of the receiver is not as owner per se, but to facilitate recovery as a security.
Thank you very much. We have a vote of thanks from Priest Ronnie Makombe, who's saying wonderful presentation, Councillor Nerima. It's very illuminating indeed. But we have a question from anonymous attendee, and he or she asks that, can an unsecured creditor commence a suit against a company in its own name that is already undergoing administrative receivership?
Is it administration or administrative receivership?
The question talks about administrative receivership.
In law, we have receivership. We also have
administration.
Yes.
I
will start with administration. We saw previously that when a company is placed under administration, there is a document called an administration deed. And who are bound by the administration deed? Let's look at the list again.
We have the directors, the shareholders, the creditors, and also the secretary, of course, as an official of the company.
Yes.
Just trying to get the slide.
The company, directors and secretaries, shareholders, administrator, all creditors in relation to claims arising on or before the date specified in the deed. When a company is placed under administration, the deed binds all creditors, whether or not you participated in the meeting. Once the company is placed under administration, the deed binds you, whether you are secured or non-secured. The exception would be if in the deed they have made exceptions. Like a deed can say that you are free to file a case. But I doubt if anyone would draft a deed and you leave room for some creditors to file cases and execute. Most likely the deed will say all creditors suspend any court action. So if you are an unsecured creditor and the company is placed under administration, you are bound by the administration deed, and most likely the deed will have a provision preventing creditors from commencing or continuing legal action or even levying distress. So that is administration. Then receivership. Does receivership stop a company from being sued? Harold, what do you think?
It depends, but there's no bar.
There is no bar.
Yeah, there's no bar. You can still sue the company because receivership can be appointed by one of the creditors. And if I'm another creditor in the equation, I have a right to sue.
I would think so, that merely because the company is in receivership, either in respect of all its assets or in respect of a particular asset, that per se is not a bar to legal action. There might be exceptions for financial institutions.
Yeah, especially if it's the very one that has appointed the receiver to proceed and commence parallel.
No, I mean a financial institution which is placed under receivership, like Bank of Uganda.
Yeah, that's different.
Can you continue the suit against the financial institution, or can you file a fresh suit? Probably that will be debated tomorrow. Otherwise, under the Insolvency Act, receivership is not a bar to commencement or continuance of legal proceedings in court.
Thank you very much. There's a related question. I think there are two concepts. The people that are bound by the administration deed as opposed to the signatories thereof. Who are the signatories to the deed? And the people who dictate the terms thereof.
A deed, although this is not under administration law training, so I don't know how much time we have to go into details of how a deed.
We might not go clause by clause in terms of designing a template, but basically giving who's the signatory, who dictates the terms, if I'm a creditor, how much powers do I have to limit on how the administration deed will affect me. Yeah.
Of course, a deed is like a contract. It is signed by the company and the administrator, but it binds all creditors. If you are a secured creditor, are you likely to support administration? Are you likely?
No.
So always there is a carve out for the secured creditor.
Yeah.
The same for liquidation. If a company is under liquidation, that does not stop a secured creditor from realizing his asset.
Sure.
The only way in which a secured creditor can be frustrated is when there is an interim order. Because you know, before a company goes into provisional administration, it applies to court for
an interim order.
one interim order. So during the continuance of that interim order, that is where the secured creditor might be frustrated. Otherwise, generally, a secured creditor is not under an obligation.
They would still have the right to recover from their assets.
Actually, that is one of the problems in corporate rescue. That most times there is a secured creditor who is not willing to listen. For him, he says, I have my...
I can realize easily.
Yes, I can realize my security. So if I'm a bank and I have a mortgage, why should I participate in meetings with workers?
Yet I can just advertise the
workers,
property.
suppliers, URA, NSSF. I will say, no, I don't care. For me, I have my security. So a secured creditor is not bound. He's always free to realize his security. The only time when he can be frustrated is if the court issues an interim order. Otherwise, generally, secured creditors are always high and dry as far as realizing their security is concerned.
Collins Tumukunde asks a follow-up question and says, can non-registration of the mortgage deed at URSB prevent an administrative receiver from acting under that deed?
Which deed?
That very administration deed. Because I think he's on the interpretation and effect of agreements under the Stamp Duty Act, and he's asking if I haven't registered the administration deed at URSB.
Under the Insolvency Act, you don't register an administration deed. I think the legal requirement is to give notice to the official receiver that the company has been placed under administration. and their registration fees for the administration deed. I'm not sure if an administration deed attracts stamp duty, but if it does, it must be negligible. Otherwise, the law is, all you have to do is to give
notice to the official
notice to
receiver.
the official receiver.
Okay. Collins to Mukunde asks, can an administrative receiver in a mortgage still act when the mortgage is not duly registered? I think that's, that cuts across with our previous question. I hope you have your answer from that.
A mortgage can be registered in the land registry and it is enforceable, or it can be registered in the company registry as a debenture.
Yes.
I think this matter has been conclusively determined. Is that GM combined versus AK detergents? The mortgage was not registered in land office,
Lands, but
there was a debenture, and the court ruled that the receiver had power to sell.
Alan Luwaga asks, does administration prevent a secured creditor from enforcing its charge? I think that has been answered. We'll proceed to Prince Ronnie. Can one company progressively go through all these stages of insolvency, depending on evolving circumstances, or each is preferred looking at the circumstances of the situation? There's a part B to that, but you can first answer that.
It is actually possible. It is possible for a creditor to appoint a receiver. It is possible for a company to go into provisional administration, then lastly, liquidation. So it is actually very possible for a company to go through all of these steps, depending on the wishes of the creditors and the wishes of the company. It's possible. You begin with receivership, and then you end with liquidation. But of course, if you've begun with liquidation, can you end with receivership? No. No. Because liquidation dissolves the company.
Yes, the part 2 of that question was relating to abatement of suits. And in light of what you shared under Order 24 Rule 6, that disallows abating, he was asking, how do you continue proceedings, especially where the Act refuses the company to sue? And how do you reconcile now the Insolvency Act and the CPR provision that you've just discussed?
Maybe what I may ask, does the Insolvency Act stop the company from suing? No. It doesn't. Only that the powers of the directors and secretary are curtailed. Yeah. So if the company wants to sue, the person to make the decision is the liquidator or the receiver.
I think it's just on the parties on who's suing. And
so it would be ABC Limited in brackets in liquidation or in receivership. But as we said, if it is a financial institution, different rules might apply. But for companies under the Companies Act, even when you are in receivership or liquidation, the company can file a suit. Only that the authority to file or to continue lies with the receiver or the liquidator, as the case may be.
Finally, thank you very much. Finally, the question that is coming through is, in the powers of the liquidator, under what circumstances should he enforce the right or seek court to have the directors personally held liable for corporate debts?
This is under lifting the veil.
Yes.
And as we mentioned, there is an intersection between insolvency and
company law.
Companies Act. When you read that case of Uganda Revenue Authority versus Crane Autos, the judge relied on both the Insolvency Act and the Companies Act to lift the veil. He relied on the Insolvency Act to lift the veil of associated companies. Then he relied on the Companies Act to lift the veil of the directors and shareholders during insolvency. One of the arguments which had been made is that you cannot use lifting the veil under the Companies Act when the company is under liquidation. But the judge was of the view that even under liquidation, you can still borrow the provisions of the Companies Act concerning lifting the veil. When you look at the definition section of the Insolvency Act, it gives a very elaborate definition of lifting the veil. Let me quickly read it. Lifting the veil means, this is a definition in the Insolvency Act, the power which the court has where the shareholders or directors of the company in question or a person in a similar position have used their business to defraud creditors. So, under the Insolvency Act, lifting the veil is allowed where the shareholders or directors have used the business to defraud creditors. So where you've defrauded creditors, the veil will be lifted. Or if you've done any other wrongful or illegal act, you will be made personally liable. So it is fraud, wrongful or illegal act. Those are grounds for the court to lift the veil. And when you go to the Companies Act, it also provides for lifting the veil. It gives some examples, including fraud and I think tax evasion. Yeah. Those are grounds where either during insolvency or even without insolvency, the veil will be lifted. And shareholders or directors will be personally liable for the debts, liabilities, and obligations of the company.
Thank you very much. I will strain you one pull of a strand more on general concept that is now common and still in this customary marriage between company law and insolvency. There's a concept of group of companies. Now, in a scenario where we have a group of companies, but it's one company that is undergoing insolvency, how best should insolvency be handled where companies operate as part of a group, but each, of course, has, as you well understand, separate legal personality? Then we can have your final parting shots and close the day.
So the answer is in section 108 of the Insolvency Act. The liquidator must apply to court. And what is this seeking? Pooling resources of associated companies. Insolvency law does not call them group. Company law talks about a group, holding company, subsidiary company. But insolvency law uses a loser terminology. Associated company, which is very wide. Which is very wide. It may not be a subsidiary, it may not be a holding company, but it says associated company. So the liquidator or a creditor may apply where it is just and equitable to lift the veil of any associated company to facilitate and ensure due completion of the liquidation process in a just and equitable manner. So when the court allows the application, it can order the associated company to pay all of the claims or part of the claims. The court can also order that the liquidation of the associated companies can only continue subject to the terms imposed by the court. Meaning, if the associated companies are also under liquidation, the court can place conditions on that liquidation. What is the overriding objective? To make sure that the liquidation of this main company continues in an orderly manner and to recover assets from
the associated.
Yes, and associated is very
wide.
It is very, very wide. If a company is owned by your wife, it might not be a subsidiary, but the court will say it is unassociated company. So as far as insolvency law is concerned, they avoid using group,
Subsidiary.
holding,
Yeah.
and they use a very loose and flexible term, associated companies.
Yeah, I think it leaves a very wide interpretation, as we've said. And Alan, to answer your question as what are associated companies? Does it include companies where the insolvent has shares or its general subsidiaries? I think it's just depends on how council has argued to either bring it under the umbrella of the interpretation of section 108, but it can be argued the example that council used, if someone's spouse owns another company, it would be different if, for example, the two companies have the same shareholders and then the other company, for example, is the main supplier in the parent company. So it is a question of case by case, and I hope we have answers on that.
When you look at section 2 of the Insolvency Act, there is a definition of associated company. It says a company or business in which the insolvency company holds majority or controlling shares. But when you read the case of URI versus Crane Auto, the court's approach was very liberal.
Or that definition of associated.
Yes, the court was looking at it more in terms of lifting the veil, generally in the interest of justice. So in this case, even if there was no proof that the insolvent company hold majority shares in the other associated company, according to the judge, that did not matter.
I think the interpretation would have been different if the plaintiff was not a tax collector, for example, because of the import of the tax aspect in the Insolvency Act as far as lifting the veil is concerned. If it was any other creditor that is not URA, perhaps section 2 would have been strictly utilized as to the definition of an associated.
But it is to the definition is quite limited to where the insolvent company holds majority shares. But the way the court interpreted, the court refused to be constrained by the Insolvency Act. The court thought it is free to apply the principles of lifting the veil generally, because in the Companies Act, lifting the veil is allowed if there is fraud, tax evasion, or any illegality. So as the jurisprudence grows, we shall see whether the Insolvency Act should be self-contained or there should be a constant interplay
between the two acts.
Between Companies Act and the Insolvency Act.
Wow. Wow. Thank you very much. We can't thank you enough for making the time. Councillor Nerima has been with us since morning, and for always lending your mind to us, your expertise to us. We are eternally grateful, and your bricks to the growth of legal practice in Uganda speaks for itself. We appreciate your time and your expertise and everything you have done for us today. Now, if you think day one has been hot, you should wait for day two. Tomorrow, we will have a presentation from Mr. Tony Karunji from URA. We've been talking about tax. They were the beneficiaries of the last decision that Councillor Nerima was talking about.
There is a raised hand.
Oh, yes. Corinne, just a minute. I will be discussing navigating the intersection of insolvency and taxation, and sharing the strategies for financial stability and compliancy. And thereafter, we will have another presentation by Councillor Fred Muwema, talking about what has been repeatedly hinted on in terms of liquidation of financial institutions and the interplay there between Insolvency Law and the Financial Institutions Act. And then we'll have a panel discussion, and on it we'll have Councillor Fred Muwema, Justin Semiyaba, Margaret Kasule, and that will be moderated by the Christian Council, Andrew Munanura Kamtera. And there we will have, we have a survey that is going on your screen. Please, will you volunteer and answer that short survey on your age group, your gender, years that you have spent in practice, the current content on training, if you find it relevant, and the effects on your training, We will also have your insight on how you found our panelists, and finally, any other topics that for the next year's conference or the other trainings that will be coming, what you find very important. Collins, your hand was up. You can type your question or comment or vote of thanks in the comments section. Yes, I think there was a follow-up. Yes, I have seen why the hand was up, and you were asking our panelists, and this is the final one before we close. But as a follow-up question to that, if a company that has not paid its employees for 6 months, can a transaction to transfer or sell its license be voidable transaction under Section 15, Section 19 on setting aside voidable transactions?
A transaction to do what?
The transaction is to sell a license, for example. Let's assume it's a telecommunications company or that have powers to sell these licenses. And he's saying that if the company that has not paid its employees, for example, for 6 months, can a transaction to transfer or sell its license be voidable in light of Section 15 and 19?
Is this a company in insolvency? Because
I would assume so.
Because this is insolvency.
Yes, I would assume so, to bring it under Section 15
As
of
we've
voidable.
seen, if there is anything to sell, be it a license or anything else, who has the power to sell it? The liquidator. And once the liquidator has sold an asset, the law prescribes how the proceeds are to be applied. As we all know, the first priority is the liquidator's remuneration. Then others follow. Where does employees' salaries fall in the hierarchy of priorities? So it is about applying the order of priorities. If the company is under liquidation, or he might be asking, what if the sale took place before liquidation? They are what we call fraudulent preferences. Was it done to favor particular creditors? For example, if you've not paid your workers, and then when you sell a license, you buy for yourselves new cars as directors. Once the company is placed under liquidation, the liquidator has a right to trace where that money went, and he will say, this was a fraudulent preference or a fraudulent transaction. The court may not cancel the sale, but the interest might be in recovering the proceeds of the sale. Yes.
Thank you very much. Collins, if the company is not in insolvency, the same applies, because in the same light that counsel has answered, you cannot talk about bringing a transaction under the Insolvency Act if the company is not in insolvency, for starters. Failure to pay employees is not in itself a precursor to bringing a company under insolvency. The employees will only have a right in the order of preference when the company is finally pressed under any of the processes that have been talked about in the current and the previous presentations by our panelists. Ladies and gentlemen, that brings us to the end of day one. I would like us, before you log out, to ask us to complete that survey that has popped up on your screen. It will assist us in furthering these trainings and conferences to make sure that better content is brought to you for the growth of the industry. So thank you very much for being a very wonderful and active audience. Thank you very much for sparing your time, for spending your money, and being part of these trainings, because you cannot take it for granted. You don't want ignorance to expose you after being appointed a liquidator or in any other official capacity. Thank you very much. Our assets pool is depleted as far as time is concerned. For day two, I have given a synopsis of what is going to take place. Until tomorrow, we are out, and may God bless you for God and our country.
Thank you so much. This was perfect. And the excellent management of time. You know, it is not good for these presentations to drag on for so long.